Okay, I'd like to call the Judiciary Committee meeting to order. Will the clerk call the roll?
Senator Sadlaw. Senator Norman. Senator Lucas. Senator Obenshain. Senator McDougal.
Here.
Senator Stewart.
Yeah,
Senator Stanley. Senator Chafin.
I think so.
Senator Deeds. Senator Peterson. Senator Serval. Senator McClellan. Senator Boysko. Senator Morrissey. Senator Edwards.
Here.
Mr. Chair, you have a quorum.
Okay, thank you very much. We plan to go to 8 o'clock unless there's some kind of uproar to that effect. We got started a little late. The first bill we'll consider is Senate Bill 530, which is Senator Locke's bill. This will have to go to Finance if it passes. So, Senator Locke, would you like to give us an overview of this bill? And there are a number of people I know would like to speak about the bill.
Thank you, Mr. Chairman.
It's Senate Bill 530. 530. It's a bill dealing with police reform. It's a fairly extensive bill. It covers a number of matters. Senator Locke.
Thank you, Mr. Chairman. Senate Bill 530 is a comprehensive bill that addresses policing reform. The deaths of George Floyd, Breonna Taylor, and Ahmaud Arbery have awoken Americans and Virginians to long-standing problems in policing. Many have asked, what does what happened in Minneapolis, Louisville, and Georgia have to do with us here in Virginia? The surfacing of a video of a Virginia state trooper using excessive force, quite similar to that used on George Floyd, shows that Virginia is not immune to the problems that Black and brown people have been experiencing for years. What has changed is social media's exposure of those incidents and the public's reaction to them. This bill is not about being anti-police or being anti-law enforcement or any of the other negative propaganda that's being used to change the narrative or to distract from the reality of what needs to be done to address the biases in our criminal justice system and the need for comprehensive policing reform measures. This bill is about setting a foundation for true equity, balancing the scales, and being proactive rather than being reactive here in Virginia. To bring about this policing reform, Senate Bill 530 does the following.
You can explain it.
It adds law enforcement officers to those persons who are guilty of a Class 6 felony if they are in a position of authority over and carnally know, without force, threat, or intimidation, any inmate, parolee, probationer, arrestee, detainee, or pretrial defendant or post-trial offender, including those in the custody of a private, local, or state law enforcement agency. It requires that a law enforcement officer provide notice of his authority and purpose prior to the execution of a search warrant. This is known as the no-knock warrant. And this should be done during the daytime unless a judge authorizes the execution of that warrant at another time for good cause shown. It requires that the Criminal Justice Services Board to adopt statewide professional standards of conduct applicable to all certified law enforcement officers and certified jail officers. The bill requires any sheriff, chief of police, or agency administrator to notify the board in writing within 48 hours of becoming aware that any certified law enforcement or jail officer currently employed by the agency has been found to have engaged in serious misconduct. The bill authorizes the board to initiate the certification proceedings against any current or former law enforcement or jail officer who has engaged in serious misconduct as defined in such statewide professional standards of conduct. It provides that any sheriff or chief of police, any director or chief executive of any agency or department employing deputy sheriffs or law enforcement officers and the director of the Department of Criminal Justice Services shall disclose to a prospective law enforcement or jail employer any information related to an arrest or prosecution of a former appointee or employee including expunged information, any information relating to a civil suit regarding a former appointee's or employee's employment or performance of his duties, and any information obtained during the course of an internal investigation related to a former appointee's or employee's alleged criminal conduct, use of excessive force, or other official misconduct. It adds a requirement for training in de-escalation techniques to the compulsory training standards employed by the Department of Criminal Justice Services for basic training and recertification of law enforcement officers. The bill also provides that a law enforcement officer should not use deadly force against a person unless the law enforcement officer reasonably believes that deadly force is immediately necessary to protect the law enforcement officer or another person other than the subject of the use of deadly force from the threat of serious bodily injury or death, that the law enforcement officer has provided a warning before using such deadly force, the law enforcement officer's actions are reasonable given the totality of the circumstances, and all other options have been exhausted or do not reasonably lend themselves to the circumstances. The bill also prohibits the use of neck restraints by law enforcement officers and bans law enforcement officers from willfully discharging a firearm into or at a moving vehicle. The bill requires that law enforcement officers intervene and render aid if they observe another law enforcement officer using an unlawful use of force. The bill expands the required law enforcement data collection for motor vehicle stops to include investigatory stops, and it also, if police fail to implement the corrective recommendations to end bias-based profiling, there is a requirement that they be ineligible for 599 funding. It also prohibits the Department of State Police and other law enforcement agencies from applying for and accepting grants or loans of personal property from the U.S. Department of Defense for use in law enforcement activities, and I believe that has been changed somewhat. The bill also provides that any locality that participates in the federal 1033 program to acquire any military property shall be ineligible for 599 funding in the succeeding fiscal year. It requires every chief police officer defined in the bill to provide the attorney for the Commonwealth access to records relating to wrongful arrests or use of force complaints or other complaints that a person has been deprived of the rights, privileges, or immunities secured or protected by the laws of the United States and the Commonwealth made against a law enforcement officer that is employed by the chief police officer's agency when such law enforcement officer has a matter before the court. It changes the membership of the CJSB and its Committee on Training by requiring that the member be a representative of a civil rights organization and 2 members be representatives of community-based organizations. It requires the Department of CJSB develop a uniform curriculum and lesson plan for the compulsory minimum entry-level in-service and advanced training standards to be employed by the criminal justice training academies approved by the DCGS services when conducting training. It also requires any criminal justice training academy approved by the Department of Criminal Justice Services to employ such uniform curriculum and lesson plans, and requires the Department of Criminal Justice Services to conduct annual evaluations of each criminal justice training academy's compliance with uniform curriculum and lesson plans. Mr. Chairman, SB 5030 is quite comprehensive, but addresses many aspects of policing reform that citizens and advocates in the community have communicated to us that are important to put Virginia on the path to a fair and equitable system. With that, Mr. Chairman, I would like to turn it over to the senator from, I believe, Southwest Fairfax, Southeast Fairfax.
Eastern Fairfax,
One
yeah.
of those Fairfaxes.
I'd like to note that Senator Serval has a substitute that he's made the motion to adopt, and Senator Deeds seconds to substitute. Is there a motion to adopt the substitute? All in favor say aye. Aye. All opposed, no. Motion carries. Senator Sherville, would you like to explain the bill further and the substitute? And it has been substantially worked on.
Mr. Chairman, where's the substitute?
It's online.
It's online. Is there a hard copy? LIS.
Just on LIS?
Yes, Mr. Chairman. This is Charles Cogliato. I released the substitute online. It should be on LIS.
Under what?
If you go to the bill page, you'll see substitutes offered. If you click on offered, the substitute will be there.
You can't pull anything up.
That's, yeah.
So if you pull up the bill on LIS,
It won't come up.
there should be a link to, it says amendments, set of committee, floor amendments, and substitutes offered. If you click on the offered link, it will pull up the substitute.
See, mine won't come up.
It's on LIS.
Okay. I didn't do it through the docket. I just did it through
I printed it out.
Okay, you got the substitute?
I printed out what was there last night. Okay.
The substitute's 38 pages long. If you got that.
Yeah, that's what I have. I printed it out.
Yeah, again, Senate Bill 5030, Senator Locke's bill, it's a substitute that's on LIS. While we're waiting for people to get that, Senator Sherwood, would you like to start going ahead and go through the bill?
Miss,
While we're waiting?
Ready to go, Mr. Chairman?
Yes, go ahead, Senator Sherwood.
Thank you, Mr. Chairman. I'm going to try and go through this bill by line number, and I believe the substitute that I'm working off of has the same line numbers as the one that's in front of the committee right now. So first of all, on page 1, line 20 through 27, this has to do with the acquisition of military property. This basically restricts local law enforcement agencies and certain private police, private police are covered in a different section, from purchasing tracked armored vehicles, weaponized aircraft and vehicles, 50 caliber ammunition, grenade launchers, and bayonets.
Mr. Chairman, question?
Senator Obenchain.
I'm just curious as to whether there are police departments in Virginia that have been accepting grenade launchers and bayonets from the Department of Defense.
Senator Sherwood.
Thank you, Mr. Chairman. What I would say to the senator is I'm not aware of any, but they were allowed to. And in 2015, the Obama administration adopted this restriction plus camouflage uniforms. And that restriction was repealed by the Trump administration. So we were just simply seeking to confirm what the Obama administration had prohibited, minus the camouflage uniforms, but the sheriffs said they would like to continue purchasing.
Mr. Chairman?
Senator Obenchain.
Mr. Chairman, I would ask whether there's any department in Virginia that's expressed an interest in acquiring bayonets and grenade launchers from the Department of Defense.
Senator Sherwood.
Mr. Chairman, I'm not aware of any, but the sheriff in Culpeper has been pretty aggressive about a lot of things. Maybe he'll want it sooner or later. This language appears in numerous places relating to different types of police departments. We've got a lot more to go through in this bill, and I'm happy to keep moving.
Well, Mr. Chairman, I'm just trying to figure out whether this is a problem or a solution in search of a problem. That's all.
Senator Sherwood.
Mr. Chairman, I'd say it's been a problem around the United States of America, and we don't want it to be a problem here. Moving on, the next, I think, substantive important change it gets to line 108. That simply applies the equipment restriction to private police departments. Then moving on to, if you get to page 11, line 290 is the next substantive change. That requires the Department of Criminal Justice Services to develop develop compulsory training in force de-escalation techniques. The next substantive change is on page 15. I'm down at line 392 through 397. Line 392 would require the Department of Criminal Justice Services to develop a statewide code of conduct for law enforcement. This was requested by the Northman Administration, Department of Criminal Justice Services, and that code of conduct that would be developed probably with a lot of stakeholder input over probably at least a year or maybe longer could become the basis for an officer decertification in the future. Lines 395 through 397, again, was also requested by the administration. That would require the Department of Criminal Justice Services to develop a uniform minimum curriculum that every law enforcement officer trained into the future would be required to undergo. Local training academies could then supplement that training criteria with whatever they wanted, but it's just to ensure that we have a minimum baseline level of training for every officer in the Commonwealth. And I'll be getting back to that in a minute. On page 16, line 415 through 416, this has to do with the Criminal Justice Services Board. We are adding 2 members to that board, a representative of a civil rights organization and, adding a civil rights organization member, another civilian member. And then similarly on page 18, lines 474 through 78, we're adding some people to the Committee on Training, 2 citizens to the Committee on Training, so there's more than just law enforcement involved in the development of training for officers. Then on line 483 through 491, this creates a curriculum on training's curriculum review committee. So this is a new committee. Again, the administration asked for this to help develop this new standardized curriculum that I referenced just a moment ago. Again, that would have not only law enforcement, but some civilian membership. Next, lines 492 on down, this is where it requires one of Virginia's 12 or 13 criminal justice training academies to employ the uniform curriculum. 499 through 504 requires them to undergo an annual audit evaluation to confirm that they're in compliance. And then lines 505 through 515 allow the Department of Criminal Justice Services to grant a waiver to any criminal justice training academy that thinks that their existing criteria is either equal to or in excess of the minimum required by the Commonwealth. This was requested by the Virginia State Police Association, which we included in the bill. Then get over to line on page 21, lines 539 through 549. This is a little bit different subject matter. Right out of the training area, now we're into HB 599 funding. And basically what this language says is that the Department of Criminal Justice Services can declare a city, county, or town police department ineligible for funding for HB 599 funding if they fail to report certain data that's required later in this bill, which I'll cover in a second, number 1, or number 2, if they've engaged in bias-based profiling, which is defined in 5230-1, which is a bill we passed this last session in the Community Policing Act. And if the Department of Criminal Justice Services finds they've engaged in bias-based policing, put in a plan for them to correct it, and then they fail to comply with that plan. That's what subsection 2 is there on 542 to 544. 545 says that any law enforcement agency will not be allowed to get increased HB 599 funding unless they become accredited. That provision right now is a delayed effectiveness for 12 months. One of the things we heard from the chiefs and the sheriffs and in our public testimony, our committee hearing a couple weeks ago, was that a lot of our law enforcement leadership feels like a lot of our any issues that we have in policing in the Commonwealth could be solved if our local agencies would become accredited. And so this provision provides an incentive to get accredited because it says you won't get any increased 599 money unless you go get accredited. And this is under the state accreditation program, not national accreditation. Then line 558, that just applies the military equipment purchase thing to the Lynchburg Airport Police. Skipping over to the next page on page 22. Lines 572 to 581, these are modifications of the Community Policing Act, which we passed last year. For those of y'all that remember, the Community Policing Act was Delegate Torian's bill that requires law enforcement to log certain characteristics of people when police departments stop them so that we can determine whether or not our local police departments are engaged in racially biased policing. What these amendments do is add to that reporting any pedestrian encounters when somebody is stopped and frisked. So if police stop somebody who's walking down the street and they pat them down, do a Terry stop, then they're also required to log this data or any investigatory detention that does not result in the arrest or issuance of a summons. And investigatory detention would refer to what the lawyers here know as a seizure. And subsection C is that report I referenced a second ago.
Mr. Chairman.
Senator Obenchain?
Now, Stewart.
Senator Stewart?
Thank you. Mr. Chairman, could I ask a quick question about that data collection?
Yes, go ahead.
Asked the patron of the substitute. I supported Delegate Torian's bill, as I recall, and the concept, but I just want to make sure that you're not collecting persons identifying data, like the individual's name and where he is, or you're just collecting race, or I would have great concerns about collecting people's identifying data and that being collected in a data bank to be used for some other purpose at some other time.
Senator Sherrill?
Thank you, Mr. Chairman. Well, given that we're not amending any of those provisions, then whatever you voted on last year isn't changing in that regard. The only additional change, which is covered a little bit later in this bill, when we get to those code sections in 52-30.2, I think, is we're also asking law enforcement to record whether or not the person who they encountered was able to speak English or not. That's the only additional factor we're asking them to collect. So if you're comfortable with that part of the bill last year, you should be comfortable with it this year unless you don't like them collecting whether you speak English or not. Yeah. Mr. Chairman, moving on. So 578 through 581, I just referenced a second ago when I was talking about the limitations on 599 money. This basically requires our local policing department to post on their website all the data that they collect, a report every year, I think is what this does. Yeah. So anything that they it requires them to post a summary report of what they capture in the community policing database, or if they don't have a website or their own report, they can post a link to the state's database where that information can also be obtained and is already going to be posted anyway. That was something the sheriffs requested. They said some smaller sheriff's departments don't have websites and they would like to just post a link to the state website. So that's what that does. Then if you skip over to 604, this gets into record sharing, and this was something that the chiefs of police, the sheriffs, the state police, all the law enforcement leadership said they desperately want and need, and that is the ability to get more information about people before they're hired. And so this basically says that going forward in the Commonwealth, right now, if somebody switches jobs, if they move from one department to the other, a lot of times the new department, the hiring department, can't get any information from the department that the officer is leaving. And so there could be all kinds of problems in their past, like use of force complaints or maybe Brady violations or or other problems in the performance of their job, but they can't get access. This says that whenever somebody moves a job, you get to look at the new employer gets to look at the entire personnel file from the last employer. And that's what lines 604 through 615 say. And then if you look on page 24, lines 617 through 623 say that if a police officer is coming from out of state, say somebody's wanting to transfer from a Maryland Police Department to a Virginia Police Department, the police officer, or I'm sorry, the new department can request a waiver or liability release so that the department can obtain the records from the out-of-state agency, because we can't tell them what to do. Mr. Chairman, I have a line amendment to that. I don't know if you want to take that now or at the end.
Why don't you go ahead and do it now?
Thank you, Mr. Chairman. On line 619, I would like to strike after in this subsection, I would like to strike subsequent to a conditional offer of employment. And as I make that motion, if there's a second, I'd like to speak to it.
Senator Deeds seconds it.
Thank
All
you.
in favor of the motion, say aye. Aye. All
Aye.
opposed, no. Motion carries.
Thank you, Mr. Chairman. Well, to explain the amendment we just made, the way the sentence was constructed, they could only request the waiver to get the records from the out-of-state department after an offer was made. They want to be able to request it before the offer is made, and so this just makes clear they can request those records before the offer is made, not after, so they don't have to offer somebody a job to get their out-of-state records. That's all it does. So then, line 624 to 20.
Mr. President, Mr. Chairman,
Yeah, Senator Obenshain.
just a question about that. I mean, this is the same situation that applies in a lot of employment situations. So what you're saying is your amendment means that if the Harrisonburg Police Department puts out a job posting and gets 20 applicants, it can get the entire personnel file for the work history for all 20 of those people before any offer is made, and look at that beforehand, as opposed to deciding I like the guy like every other employer in America does, and then make a conditional job offer and then get that information. Is that right?
Senator Sherrill.
Thank you, Mr. Chairman. I would say to the senator that I think he's mostly correctly analyzed that. The only footnote I'd give to that is that by making the amendment, we're treating people moving from out of Virginia into Virginia the same, whereas the way this was constructed is written, if you were moving from one Virginia department to another Virginia department, they could obtain the 20 records from the 20 people in the Virginia departments ahead of time, but if the person was coming from out of state, they have to make them an offer before they can go get their out-of-state records. So this just basically makes it the same. If your discomfort is with the policy of getting the records before the offer is made, then this entire paragraph B would require an amendment as opposed to the words that we just struck out. So,
Mr. Chairman, I thank the gentleman for pointing that out.
thank you, Mr. Chairman. So moving on to line 624 through 26. My colleagues on the other side might remember this language from a bill Senator Carrico carried in 2018, along with Delegate Danny Marshall. They had put in legislation to require a psychological examination before somebody's hired as a law enforcement officer. That bill was unsuccessful. This simply puts in language that says they may require it. And you might ask, why would we put in may instead of shall? What's even the point of putting it in the code? The law enforcement, the chiefs of police, I believe the sheriffs, they all said that they would love to be able to do psychological examinations before people are hired. Actually, most agencies already, most of our big police departments already do this. But there's concern about whether or not we have enough police psychologists in Virginia to mandate it to every single 400 of the 400 agencies in the state at this time. And as more police departments become accredited, as we anticipate with the language in this, you'll see more demand and more need, more infrastructure, human infrastructure built to do these psychological examinations before people are hired. But they said right now they don't think we have the capacity for it. And so they thought by putting it in the code as a may, it would encourage local police departments to start doing these. So that's why the language is there and it just says may and not shall. Okay, page 25, 647 through 658. This is one of the more important provisions of this bill. This has to do with decertification. And again, this is something that the chiefs, the sheriffs, law enforcement leadership, DCJS have been asking for. This basically makes it easier to decertify a police officer. The existing law basically says that you can only get a decertification proceeding can only commence after you've been convicted of a crime or tested positive for drugs, I believe is it. And so basically what this does is, first of all, on line 649, and throughout, it makes it clear that decertification proceeding can be started or continued even if you resign during a decertification proceeding. So right now, somebody can start a decertification proceeding, but if they resign, if an officer resigns in the middle of the proceeding terminates. And so many law enforcement leadership told us during this process, they know of a lot of officers that basically decertification proceedings commenced, they resign, and then they move and take another job somewhere else. And because the records aren't shared, the new agency has no idea that they were even going through a decertification proceeding. So basically this ends that practice so that if you're either terminated or resign while a process is going on, you can still be decertified, number one. Number two, this expands the grounds for decertification. In addition to the two things I laid out before, it allows for decertification if you're terminated or you resign for a violation of state or federal law, if you're terminated or resign for engaging in serious misconduct defined in the statewide professional standards adopted by the board. And remember, I talked about that earlier, the state code of conduct for officers that DCJS is going to develop. Letter V on 654. If you terminated or resigned while the subject of a pending internal investigation involving serious misconduct. So not after a decertification proceeding has begun, but there's actually an internal investigation going on. And then lastly, VI on lines 656 through 58. That is if you are terminated or resigned for basically a Brady violation. And for those of you who aren't attorneys, a Brady violation is when a police officer withholds exculpatory evidence, that is evidence that would tend to show somebody's innocent, or if they are dishonest during the course of a case and they're found to have lied to a judge basically. Whenever that happens, that has to be disclosed in every single case the officer is involved in afterwards, which usually makes an officer radioactive for future criminal cases. And so this idea, by the way, for the Brady violation being grounds for decertification came from Colonel Pike during our Senate testimony that we had a couple weeks ago. And we've refined this language after a lot of conversations with law enforcement about a fair way to do this. So then moving on to page 26. Lines 671 through 74. This allows a decertification again to start before anybody's been convicted. Right now, there has to be a conviction first. Lines, and then moving down to lines 679 through 690. This just makes clear that if an agency shares records, they won't have any liability for that when somebody changes jobs. 692 to 699 applies the military hardware restrictions to, I don't know, maybe additional local policing agencies. We had to put this in here in a couple different places to cover all the different agencies there are. Then 700 through 712, this gets back into the Community Policing Act, which I think Senator Stewart just queried me about a second ago. Again, this just has language that parallels what we talked about before about stop and frisks for pedestrians. 713 through 741, Senator Marsden's bill from last session, which passed this body unanimously, which didn't make it out of the other body, but it's the bill that basically prohibits a police officer from having sex with somebody they've arrested. This is against the law in most other states, but not here. Then, let's see, getting on to line 740, let's see, going down to page 31, lines 817 through 828. This has to do with search warrants. So, lines 817 through 822. First of all, 817 through 818, this prohibits no-knock warrants, period. That's what basically lines 817 through 818 do. 818 through 822.
Mr. Chairman.
Senator
Stewart.
Senator Stewart.
Mr. Chairman, I've studied this and I have some concerns here I'd like to question the patron on the substitute a little bit about. I noticed on lines starting on 817 through 818, it says that a search warrant authorized under this section shall require that a law enforcement officer provide notice of his authority and purpose prior to the execution of such search warrant. And if you stop there, to whom do you provide notice of his purpose and his authority?
Senator Sorrell.
Typically to the front door.
Well, Mr. Chairman, I guess my question would be, should that be set out here? Because it doesn't say who who you're supposed to notify. And if you read down, the exclusionary rule applies to this so that if a court determines that notice of the authority and purpose was not given to the proper person, all the evidence as a result of that would be excluded from trial. And so let me start by saying this. I've practiced law for 30 years. I've seen the problems that this body is trying to fix, and I support the concept of trying to do that. But the search warrants part is a very, very complicated body of law, and I think we better take the time to try to get it right. Because a good lawyer could take that language and they could have all of the evidence obtained from a search warrant excluded in the trial, and I don't think that's what anybody wants. And that language concerns me as it does as you go on down. But that was my first question. So I guess to the substitute I would say, should you not identify to whom you're supposed to provide notice of your authority to?
Mr. Chairman.
Yeah, Senator Sorrell.
Thank you, Mr. Chairman. And I'm happy to sort of ask counsel here the best way to word this, who came up with this, but I would say to the senator, I appreciate his concern. I think it's important that we be careful about this. The reality of these of warrants is that you often don't know who's behind the door. You don't know if the owner's there. You don't even know if there's an occupant there. And obviously, we don't want to create a situation where they have to actually make contact with a human being before they go in. I don't think that's the intent. I think the idea is just that when they show up to do a warrant, you have to go, knock, knock, police, and that's good enough. That's my point. And so if the intent was to come up with that requirement, and so if counsel or anybody else has a better way to word that, I'm all ears. But I think we're in agreement of what we're trying to accomplish. We just want to make sure the words are right. So I don't know if Mr. Benjamin or Mr. Quagliato might have some feedback on a clearer way to word that.
I can give you a suggestion.
Any comments from Steve Benjamin?
Mr. Chair. Okay, can you hear me?
Or Steve Benjamin or
Mr.
Charles?
Chair. Yeah. Am I being heard?
Mr. Chair. It's Peterson behind you.
Senator Peterson?
I have a suggestion. I don't know. Okay.
All right.
Look, on line 18, this is just a suggestion.
Can you speak up a little bit, Steve? I can't hear you.
You can't hear me?
Yeah, we can.
A little bit louder, please.
Okay, can you hear me now?
Just speak up louder if you can.
I'm already yelling.
Mr. Chair,
Senator Peterson.
what if we did, instead where it says provide notice of his authority, I think the word notice can mean all sorts of things. It could be talking about sending a letter to the Secretary of the Commonwealth. I mean, instead, I think what you're really talking about is a law enforcement officer shall announce his authority and purpose prior to the execution of such a search warrant. Isn't that what we want? We want a loud statement saying, the police, you know, we're the police, we have a warrant.
Hey,
Yeah.
can you hear me better now?
Steve, Steve, go ahead.
Okay. On line 18, after the word provide, insert audible.
What?
On the same, insert the word audible. On the same line, after the word purpose, insert reasonably sufficient to be heard by the inhabitants of any place to be searched, so that it would then read, a search warrant authorized under this section shall require that a law enforcement officer provide audible notice of his authority and purpose sufficient to be heard by the inhabitants of any place to be searched prior to the execution of such search warrant.
Okay, Senator Servo.
I would make that motion.
Senator Locke, seconds a motion? No. Somebody, is there a second?
McClellan.
Okay, Senator McClellan seconds the motion. All in favor of the motion to amend, say aye. Aye. All opposed, no. Motion carries. Continue, Senator Sherrill.
Thank you, Mr. Chairman. So the next part of the bill, lines, let's see, 819 through 821, require any warrant to be served during the daytime unless they get permission to serve it at night from a judge. And if they can't find a judge, they have to lay out why they couldn't find a judge in their affidavit.
Mr. Chairman.
Senator Stewart.
Stewart, thank you. Mr. Chairman, I would point out to the patron, and I think I mentioned to him earlier, if you go to line 763 under the warrant provision, it says the warrant shall command that the place be forthwith searched either in day or night, and that the objects and persons described in the warrant if found there be seized. And that's been language since I went to law school, I think. Does this language now not conflict with the language on line 763, and what do you do about that?
Mr. Chairman.
Senator Servo.
Thank you. Unless council disagrees with me, and I appreciate the senator pointing this out to me earlier, given that lines 818 through 20 allow for a warrant to be served at day or night, provided certain requirements are met, it would seem to me that they're consistent and that this more specific provision would govern whether it has to be a day or night if these boxes are checked in lines 819 through 21. If I don't know if Mr. Quagliato or Benjamin disagree with my interpretation of that, but that's how I think they would be read together by a court.
Council,
Mr.
any
Chairman,
questions?
Mr. Chairman, I don't disagree, but to avoid any confusion on line 763, you could strike the provision either in day or night.
Yeah, Mr. Chairman, this is Charles Quagliato, and I agree. I think the reason why I left it in was exactly the way that Senator Servo described. Was it seems to me it allows for either option. So rather than to change the language, I agree that the more specific language in 819 or 820 would control. But to be clear, if you want to strike the either in day or night, we can.
Yeah, Senator Deeds makes a motion.
I second that.
It's been moved and seconded that language in 763, line 763, be stricken. Moved and seconded. All in favor of the motion, say aye. Aye. All opposed? No. Motion carries.
Thank you, Mr. Chair. Keep going.
You keep going.
Thank you. On lines 821 through 22, it also makes clear that a search warrant for blood, which is most commonly obviously happens in DUI cases, can happen at day or night. Doesn't matter. You don't have to get special permission for day or night on a search warrant for blood. Just execute that whenever you've got it in your hand.
Mr. Chairman.
Senator
Stewart.
Senator
I'm
Stewart.
sorry, this is a very important area to me, and I'm afraid we're going too fast on it. I would also ask the patron and perhaps council, starting at 685, a law enforcement, it says a law enforcement, I think it should be officer after enforcement on line 685, shall make reasonable efforts to locate a judge before seeking authorization to execute the warrant at another time or without such notice. Such reasonable efforts shall be documented in an affidavit and submitted to a magistrate when seeking such authorization. That, to me, is a very subjective standard. And would the court have the authority to second guess that subjectivity and say, well, no, I don't think they did make a good faith basis to get it, despite the fact that the magistrate felt they did in their affidavit. And so should that not be set out in better fashion, I guess is the only way I can say it. To the patron of the substitute.
Mr. Chairman, I share the concerns that were just expressed. It's my impression that the mechanism that you see before you is the result of the committee trying to accommodate input from law enforcement stakeholders. An alternative approach to this would be to permit the nighttime execution of search warrants only when authorized by a judge, period. That's a policy question for the committee. It has a tremendous amount of merit, and it avoids the problem that Senator Stewart has just identified.
Mr. Chairman.
Sherville.
Thank you, Mr. Chairman. And I appreciate Mr. Benjamin's analysis of it. His diagnosis as to how this language got created is absolutely correct. The original version that was being circulated, which you all probably can look up on LAS, I believe, said that a warrant can only be served at night unless you get authority from a circuit court judge. And in the vetting process, the sheriffs and the chiefs of police expressed concern that in some parts of the Commonwealth, circuit court judges can be difficult to locate at certain times of night and with distances. And so they wanted the flexibility to be able to go to a magistrate if they couldn't find a judge. And that was where we came up with this language. And that's how we got here. That's all I can say.
Mr. Chairman. Mr. Chairman,
Stewart.
I one more fly in the ointment. In conjunction with that, I'm also concerned about the fact, and I mentioned this to the patron of the substitute as well earlier, there is no exception in here for exigent circumstances. And all the lawyers in this room know what exigent circumstances are, but the best example I could give, you got MS-13 gang, and they're in Fairfax, and you know they're there, you know they're about to commit a murder, you have warrants to serve on them, you can stop it, you can save somebody's life, but you can't find a judge, magistrate, you don't have the time, and therefore you can't go in. So it would appear to me that some sort of exigent circumstances exception needs to be drafted, and that's a bigger lift than I can do today. But there needs to be some kind of exigent circumstances in this bill.
Senator Deeds.
Mr. Chairman.
Mr. Chair, under current constitutional law, doesn't exigent circumstances exception exist all the time? I mean, can't
Mr.
a
Chairman.
police officer, if exigent circumstances exist, can a police officer do what's necessary?
Mr. Chairman,
Mr. Chairman.
my response to that would be yes, except in the execution of a warrant, because you've just now limited with specific language that you could not do that. But as of the law today, you would be able to do what you want to do or need to do under exigent circumstances. If you pass this language as it is, you would not be able to.
I don't think we
Mr. Chairman.
Yeah, Senator, who's, Senator Dees, Senator Sherrill, Senator
Morrissey.
Stewart? Anybody want to comment?
Mr. Chairman.
Senator Morrissey.
Yep.
Senator Morrissey.
Thank you, Mr. Chairman. I think Senator Deeds is correct. I'm not so sure with respect to Senator Stewart's inquiry. I don't think we have to spell out exigent circumstances or the automobile exception to the search warrant requirement or the fleeing felon exception. It is implied. And maybe we need to, I can ask staff, Mr. Benjamin or Charles, about this, but given that those exceptions to the search warrant requirement exist in case law, do we have to spell it out in this omnibus bill?
Staff, council?
Depends what you want. If the exigent circumstances would permit the police to enter a house without a search warrant, that's existing Fourth Amendment law. Under this bill, they would still be able to do that. If, however, the police execute a search warrant that's been obtained under this bill, then it must be in compliance with what has been set out in this bill. If there are true exigent circumstances, I think the reality is that the police would not be going to get a search warrant, and so I think that it would be an imagined problem. I think if there were true exigent circumstances, the police would do what you would want police to do. They would storm the house and rescue the people. There would be no search warrant, hence there would be no violation of this subsection.
Okay, Senator Sherrill. Continue.
Thank you, Mr. Chairman. So that's I think it for the search warrant piece. Moving on to line 30 or page 32.
Before you go any further, if I may, on line 827, I wonder if the patron would have any objection to inserting after the word evidence the words "for the Commonwealth."
I'm not the patron, but I have no objection.
All right.
I would make that motion.
Motion's been made.
Second.
Senator Deeds seconded. All in favor of that motion to insert those words, say aye. Aye. All opposed, no. Motion carries.
Thank you, Mr. Chairman. So moving on to line 843. This has to do with law enforcement officers' use of force during arrests and detentions. And there's a lot of different ways to do this. I know that I believe the senator from James City County has an approach. I believe the senator from, the junior senator from Richmond, I think, has an approach. Basically, the idea here was to create a new chapter in Title 19.2 that we could point at for purposes of creating some baselines when it comes to officers' use of force in general and also for purposes of decertification. So 843 to 852 is the definitional section. 853 through 55, this has to do with chokeholds. And this says that chokeholds cannot be used in Virginia anymore unless it is immediately necessary to protect the law enforcement officer or another person. So it's not a complete chokehold ban, but it says you can only use a chokehold if you're in fear basically of your life or the life of somebody else. 856 is language that prohibits the discharge of a firearm into or at a moving motor vehicle, again, unless necessary to protect the officer's life or the life of another person. And by the way, with regard to these two provisions, all of the law enforcement professionals that we've interacted with as a part of coming up with this bill have all said that this is how they currently train their officers. Nobody trains chokeholds, and nobody trains anybody to shoot at a moving motor vehicle. And that's required by accreditation, all the accreditation agencies, and that's what professional departments do. So everybody's fine with that. Then 859 has to do with, lines 859 on down has to do with the use of deadly force. And so basically what this incorporates is the concept, if you want to read a case, you want to find out where this comes from, the case is a United States Supreme Court case. It's called Graham v. Connor, and had to do a situation where a guy was in diabetic shock, and he went and got an orange juice or something at a 7-Eleven, and police officers chased him down, pulled him out of his car, threw him on the ground, and injured him. And the Supreme Court came out with a series of standards that law enforcement is to abide by when executing an arrest in terms of the force that's necessary. But this is an attempt, I think, to codify Graham v. Connor. And basically, if you look at lines 860, it says that you can't use deadly force unless it's immediately necessary to protect a law enforcement officer or another person other than the subject to the use of deadly force from the threat of serious bodily injury or death. It also says in 864 that law enforcement is to provide a warning to the subject of deadly force that he will use it if feasible, given the totality of the circumstances. And then in evaluating the reasonableness of the force, it lays out a series of circumstances that are to be looked at. In Graham v. Connor, the U.S. Supreme Court said that we are to evaluate a police officer's actions based on an objective standard, not a subjective standard. That means we're to evaluate it from a reasonable police officer in the situation of the officer without the benefit of hindsight. We are not to evaluate it from the subjective perspective of the police officer. That is what that officer, he or herself thought. And that's what these factors on 870 through 882 have to do with. They have to do with the amount of time available to the officer to make the decision, whether or not the subject of the force possessed a deadly weapon, whether or not the subject of the deadly force refused to comply with law enforcement orders, whether the officer tried to de-escalate the situation prior to using deadly force, including taking cover, waiting for backup, trying to calm the subject prior to using the force, or using non-deadly force prior to using deadly force, and whether or not the conduct of the officer prior to using the deadly force intentionally increased the risk of confrontation resulting in deadly force being used, and also the seriousness of the crime that the officer is investigating. We spent a lot of time with law enforcement crafting this language, coming up with these factors, both the factors, the first set, and also the mitigating factors. A lot of time went into drafting this. Then, if you go to the next page, lines 883 through 895, this has to do with the failure to intervene. And it basically says that a police officer who witnesses another law enforcement officer attempting to engage in the unlawful use of force in this chapter, if they see it and they don't intervene, there could be consequences for that. And it also has in subsection B, which is 889 to 95, a whistleblower protection language, which was requested by the administration as part of this process. And then 896 through 900 makes it clear that or it sort of sets out the penalties for violating this new chapter, which is basically disciplinary action, dismissal, demotion, suspension, transfer, decertification. And then line 901, this gets into new subject matter. So, what this has to do with is requiring, this was requested by the Commonwealth attorneys. This basically requires a police department to provide information regarding an officer's use of force, internal affairs investigations, disciplinary records to the Commonwealth attorney upon request. I'm not sure how many people here are familiar with the John Gear case out of Fairfax, which is probably the most notorious, but there was a man in Fairfax County who was shot in his front door holding a cup of coffee, and the Fairfax County Attorney's Office refused to turn over records to the Commonwealth Attorney's Office for over 3 years, which delayed the charging decision. Of course, the Commonwealth Attorney got blamed for it, but they couldn't get access to the records they needed in order to conduct an investigation, and this would solve that problem. And again, there's about 11 Commonwealth attorneys who requested this information, and we worked it through to make clear that it doesn't apply to records that are protected by HIPAA or other sort of minor trivial stuff. And that's the HIPAA stuff's on 931 to 32, and the language between 918 and 930 is the non-serious stuff. Then the next has to do with, again, the military property acquisition. Then 948 through 63, again, is the community policing stuff, which we've talked about before. Cleaning up that Community Policing Act based on the changes we're making here. And then we have a series of enactment clauses. Number 2 is just because there's some new crimes that come about because of this. Enactment clause number 3 has to do with the development of regulations. Enactment clause number 4 is the delayed enactment clause, which gives more time to law enforcement to implement the provisions of these things. And 15.2, I'm sorry, enactment clause number 5 makes clear that a police officer cannot be decertified going forward based on things which were not in the Code of Virginia when their conduct occurred. So we're not going to go back and start decertifying people based on things that happened in the past. This will only operate to decertify people prospectively. Mr. Chairman, that is the bill. I want to say, first of all, I appreciate the patron allowing me to work with her on it. I really appreciate the input from the Virginia State Police Association, the Virginia Sheriff's Association, the Virginia TISA Police Association, a lot of other people who've provided a lot of input in the process, VACO, VML, the administration. There's been a lot of people who've had input into this. I've shared it with the members of this committee over the last 2 or 3 weeks as we have refined the language. And Mr. Chairman, having so stated, I have a motion at the appropriate time unless there's more questions.
Mr.
Are
Chairman.
there any questions of the patrons?
Mr. Chairman.
Senator Locke or Senator Serval?
I have one question still.
I can't see.
Stewart.
Senator Stewart. Okay.
Yes, Mr. Chairman, thank you.
Okay, Senator Stewart.
Mr. Chairman, going back, and I went back and re-looked at this, to line 572 says the sheriff of every locality shall collect data pursuant to all investigatory motor vehicle stops, all stop and frisks of a person based on reasonable suspicion, all other investigatory detentions that do not result in an arrest. And I guess my question would be to either the patron or the patron of the substitute, should we define data? As you all recall, we had a great deal of debate and discussion some years ago about these license plate readers and it collecting people's data going down the highway and then that data being subpoenaed for other purposes that you may not want it subpoenaed for. And this just doesn't say, well, it doesn't say race or ethnicity or language. And so I assume they're going to collect a person's name, age, et cetera. And I don't know if we want all that.
Senator Serval.
Mr. Chairman, so I think,
You see the line I'm talking about?
yeah, and I would just, first of all, again, remind, I think the gentleman that I think this section was adopted last year, and I think you have to read it in conjunction with section 52-30.2. I don't know if you can pull that up on your device or link to it, but
Not that good.
I got it right in front of me here, and it says every time a law enforcement officer or state police officer stops a driver of a motor vehicle, such officer shall collect the following data based on the officer's observation or information provided to the officer by the driver. 1, the race, ethnicity, age, and gender of the person stopped. 2, the reason for the stop. 3, the location of the stop. 4, whether a warning, written citation, or summons was issued, or whether any person was arrested. 5, if a warning, written citation, or summons was issued or an arrest was made, the warning provided, the violation charged, or the crime charged. And 6, whether the vehicle or any person was searched. And we're adding to that, I think on line, if you skip ahead to line 950 or 960, we're adding to that whether the person spoke English. And then on lines 964 to 65, whether the law enforcement officer or the state police officer used physical force against any person, and whether any person used physical force against the officers. So we're basically adding whether they spoke English or whether or not force was used by either the subject or the officer. So I think you read the two together, it doesn't appear to me that in this community policing database that the state will be keeping that anybody's name or address or license plate number is being reported to the state police. I suspect it'll be kept by the local agency, but it won't be kept by the police, by the state police in that community policing database.
Thank you, Mr.
Okay,
Chairman.
if there's no further questions of the patrons, the public.
Mr. Chairman?
Yeah, who's this?
It's Steve Benjamin.
Steve.
Just a couple comments, sir. On lines 572 through 574, the section that Senator Stewart was just asking about, my question for the committee or for the patron is why this language is necessary. Under current law, the sheriff of every locality shall collect data pertaining to motor vehicle or investigative stops, which covers all possible stops that you would want to collect data from. The new language narrows the types of stops for which data would be collected. And so my first question is, or my first comment is, I don't think that this new language is necessary.
Mr. Chairman.
Senator who?
Sherville.
Sherville.
Thank you, Mr. Chairman. First of all, I think this language on 572 to 74, I believe, if I'm not mistaken, it appears to apply only to sheriffs. And this was an attempt, I think, to make it consistent throughout the code between state police, local law enforcement, and sheriffs, which is why these amendments had to be made in 3 different places. But with regard to this language, I believe the intent was to pick up pedestrians or stop and frisks of pedestrians.
And Mr. Chairman, that's my confusion, because current law requires data collection for all motor vehicle stops and all investigative stops. An investigative stop is a pedestrian detention.
Mr.
Now,
Chairman.
let me go a little bit further to point out that a police officer can stop and detain a person if he has reasonable suspicion that a crime is being committed, but he cannot frisk that person unless he has an additional suspicion, articulable, that that person is armed. And as it's worded right here, if an officer conducts an unlawful frisk of a person, then no data is required, because we're limiting it to those stops that also include frisks and which are based on reasonable suspicion. And so here I'm pointing out, in addition to a concern that the language is not necessary, if the sense is that new language is necessary, you might consider simplifying it so that the requirement, not only for the sheriffs, but for the other agencies affected, would be that they shall collect data pertaining to all detentions, frisks, and motor vehicle stops.
Senator Sherville.
Mr. Chairman, I think that's consistent with our intent, and perhaps it might be clearer, although the language I think we're tweaking might have been in the bill that came through this committee last year that we already approved, but if Mr. Benjamin thinks that makes the intent clearer and does not change the law from last year in a way against the intent we're trying to accomplish, I think that's probably a good amendment.
And that would go to each of the sections that have been amended.
3 places.
Senator
Yes.
Sherville, you want to make that
I'll
amendment?
make that motion.
Who?
Surville made the motion.
Right. Sherville, you made the motion. Would you state it again
Hold on
clearly?
a second.
State the motion again, Senator Sherville.
I make the motion to make the amendments in the 3 places that Mr. Benjamin has suggested. We tweak the language to make it clearer.
Oh, okay. Mr. Chair?
Who seconded?
No.
Boy Scout seconds.
Senator Deeds seconded. Somebody else want to say
Senator
something?
Peterson.
I got a question.
Senator Deeds, he has a question.
I have a question.
Oh,
Peterson.
Senator Peterson has a question.
Okay, my question is, it appears to be whoever wrote this bill wanted to be more precise in terms of when we collect data, and they particularly talk about all investigatory motor vehicle stops, as before previously was all motor vehicle stops. I mean, there could be motor vehicle stops for any number of reasons. Could be an expired license, could be a inspection sticker, could be a DUI. I mean, I take it, to me, it seems it was intentional that they put in the word investigatory, just like
Mr.
they
Chairman.
said all stop and frisk based on reasonable suspicion.
Senator Serval.
Mr. Chairman, to answer the senator's question, I believe the reason, I believe the things he just articulated are investigatory stops, but I believe the reason that this was clarified in this way was because, as written, it would pick up roadblocks. And if you got 300 cars going through a roadblock where you're
Right.
just checking in with the person real quick and sending them on, trying to log all that would be kind of burdensome. I believe that's why council suggested that we put the word investigatory in there as opposed to not every stop. I think. Mr. Quagliato can answer, correct me if I'm wrong.
Mr. Chairman, that is correct.
Yeah, Mr. Chair.
Senator Peterson.
Having said that, I think the way it is right now is actually okay, because there's all sorts of reasons that a vehicle might come to a stop and there might be a police officer standing at the window. You're getting into a stadium. You're doing whatever. I think the way it's written right now is actually pretty good. So I think we should leave it.
Okay, Senator Serval. Are we finished? Any further questions of either of the patrons?
No, Mr. Chairman, this is Steve Benjamin again. On line 847, this is the definition of deadly weapon for the section dealing with use of deadly force. On line 847, we say deadly weapon means any object other than a body part or stationary object. The question for the committee or for the patron is whether the words other than a body part or stationary object should be deleted from the bill. For example, one might imagine a law enforcement officer seizing a person's head and slamming it down onto a concrete surface. Certainly that would be deadly force, but it would be excluded by this bill.
Mr. Chairman.
Senator Serval.
Thank you, Mr. Chairman. Yeah, we actually discussed this at length, and the problem that you create by calling a body part a deadly weapon, which I believe Senator Saslaw said that his hands were a deadly weapon at one point in time, maybe still today. We all know Bruce Lee probably thinks his hands are deadly. Is that if you include body parts in the deadly weapon list, it reads the language that comes later on lines 877 moot, because under line 877, one of the mitigating factors in terms of whether you can use force is whether a deadly weapon is present. And if a body part is a deadly weapon, then a deadly weapon is always present, and therefore that's always a strike in favor of using deadly force. And so that's why we thought it was important to exclude body parts from the deadly weapon category.
Okay, any further discussion? Okay, are we finished? Any further questions of the patrons? Any council want to say anything else? Because
Mr. Chairman, yes, on line 888. This is under the section failure of a law enforcement officer to intervene. On line 888, this bill requires that an officer provide, if circumstances permit, that an officer render aid to any person injured as a result of such unlawful use of force. The question is whether an officer shouldn't an officer render aid to any person who has been injured because of the use of force, lawful or unlawful. And so the solution there, or the suggestion, would be to delete the words such unlawful and insert the, so that an officer has an obligation, if circumstances permit, to render aid to any person injured as a result of the use of force.
Is there a motion to accept that as a friendly amendment? Senator Serval? Senator Serval moves, Senator Deeds seconds that motion, that amendment. All in favor of the motion say aye. Aye. All opposed, no. Call the roll. All in favor of the motion, call the roll. In favor of the motion, vote aye. All opposed, no. Vote no.
Senator Sadlaw. Senator Norman. Senator Lucas.
Aye.
Senator Obenchain. Senator McDougal.
No.
Senator Stewart. Senator Stanley.
No.
Senator Chafin. Senator Deeds.
Aye.
Senator Peterson.
Senator Peterson.
Leave him alone.
Senator Serval. Senator McClellan. Senator Boysko.
Aye.
Senator Morrissey.
Aye.
Senator Edwards.
Aye.
8 ayes, 7 nays.
Motion carries. All right, any other comment for anybody? Are we ready to hear the public? Okay, we have 7 members of the who signed up, plus another crowd of people
Mr.
from
Chairman.
the public would like to say
Mr.
a
Chairman,
word.
Senator
Senator Serval.
Senator Boysko is trying to speak, but her
Senator
mic's
Boysko.
not working.
Mr. Chair, I just have a clarification. I thought we had a motion and a second on the piece around the sheriff's stopping. Did we pulled that out? Okay. I just wanted to clarify. Thank you.
Okay, we're ready to hear from the public. I said there are 7 people who signed up, plus a crowd of other people would like to say a word or two. I hate to limit, because this is a big bill. We spent an hour and 25 minutes on this bill. It's a huge bill. It's been looked at very, very carefully. And John Jones will be the first person up to say whatever he would like to say. John Jones, are you here? Yeah, is John Jones here?
Yes, sir. Can you hear me? This is John.
Go ahead.
Okay, here we go. Can you hear me?
Yes, we can. Thank you.
Okay, thank you. Thank you, Mr. Chairman. And I want to say on behalf of the sheriffs to Senator Serval, thank you very much for working with the association very much over the last week or two, especially over the last weekend, to accommodate many of our needs. A number of the elements in this bill, I'm not going to go over them in detail. You've done that already, but the most important part of the several parts, you fixed as far as we're concerned, you fixed the military equipment. Some of the concerns, sheriffs do use that for rescue and protection, and you accommodated that. The de-escalation clause is good. One of the most important elements that I think is in it is probably the most important element for us is decertification, and it expands the elements where officers can be decertified and provides immunity for sheriffs when they share information when they move from one office to the other, or from one police department to a sheriff's office. There is one section that I want to just bring up. It's over on line 925, relating to the information to the Commonwealth Attorney. And while we don't object to the language on 924, the forfeiture, the criminal matter, the criminal investigation, the words there are in a serious matter. That's everything we do is serious, and it's very broad to include that we have to turn over this information on these officers for any serious matter. So we would recommend that be taken out. That's the only recommendation to make any changes, Mr. Chairman. And again, I want to say we've sent this out to the sheriffs. Our leadership has worked on it. For the most part, the sheriffs agree with it. We have a policy committee. They voted for it overwhelmingly in favor of the bill after the amendments were adopted, after we worked with Senator Serval. So with that, Mr. Chairman, I'm going to conclude my remarks and answer any questions anyone might have on the sheriffs, and then remind you that we would like to see a change on line 925 to tighten up any serious matter. Thank you very much.
Thank you very
Mr.
much,
Chairman.
John.
Mr. Chairman.
Senator Stewart, who's this?
Mr. Chairman.
Senator
Yes, sir.
Sherrill.
Thank you. I'm happy to make the motion to strike the language on line 925, basically anything after the word investigation. Then I guess we'd have to add the word or on line 924 after criminal matter.
Striking any serious matter?
Right. We have to add the word or back in to make it read like an English sentence.
Okay, add or and strike out any serious matter, okay? The motion's been made. Senator Deeds seconds it. All in favor of the motion say aye. Aye. All opposed, no. The motion carries. Okay, next person up is Annan Kofi of Washington, of Herndon. Not in the room. Okay, sorry.
He just texted me and said he's been trying to get in. I'll get him in back in.
Okay. Next person, Tanya Shart from Washington, D.C. In favor? Is Tanya here? Tanya Shart, S-C-H-A-R-D-T, Shart.
Hi there, can you hear me?
Yes, we can hear you. Thank you. Yeah, go ahead.
Hi there. Tanya Shart from Brady. We at Brady understand that necessary reforms to our policing systems must include improvements to policing trainings and standards, including standards on the use of force, as well as robust transparency and meaningful mechanisms to ensure accountability. This bill includes each of these, and we urge the committee to pass this bill. Thank you so much.
Well, thank you very much, and thank you for being short. We appreciate hearing from you. The next person is Tara Taylor of Yorktown. Tara Taylor. Is Tara Taylor here? We'd love to hear from you. Apparently not. Bradley Reinheimer of Williamsburg. Bradley Reinheimer of Williamsburg. Are you here?
Go on.
Bradley Reinheimer from Williamsburg. Are you here? All right, we move on to Douglas.
Sir, can you hear me now?
Bradley Reinheimer?
Yes, sir. Can you hear me, Mr. Chairman?
Yes, very much. Thank you. Go ahead.
I apologize for that. Thank you, Mr. Chairman and committee members. I appreciate the time. My name is Brad Reinheimer. I'm the police chief in James City County. I'm also an executive board member for the Virginia Association of Chiefs of Police and a commissioner on the Virginia Law Enforcement Professional Standards Commission. I want to start by saying how much I appreciate all the work that you all have done. I know when this bill was first talked about and things first came out, there might have been a little bit of a difference in opinion in many of the concepts, but I appreciate all the work that's been done on behalf of all those stakeholders in the law enforcement system and your committee and everyone to come up with reasonable legislation that we feel will improve professionalism, increase accountability, and also increase transparency in law enforcement, which is what we're all shooting for. I want to talk specifically about one issue in the bill, and that deals with the requirement for accreditation. We presented 7 recommendations to the governor as a board, the Virginia Chiefs did, and the number one recommendation that we talked about was accreditation and how that can solve many of the issues that we feel we're trying to address through some of this legislation. I appreciate all the work that's been done with accreditation, but the way the bill's currently being introduced, the year time frame, I don't believe would provide the time that would be necessary to be able to get law enforcement agencies into the accreditation process. It's a very lengthy process. As you know, staffing with DCJS is not such that, increasing it threefold, which is what we're trying to do, don't know that it could accommodate that. Not to mention the time that it takes for police departments or sheriff's offices to get policies and procedures up to date to be able to come into compliance so they can meet that accredited standard. So we're asking that that be considered to be extended up to maybe 36 months to give time for that, or at least studied so we can look at a time frame that we feel would be more reasonable.
Mr. Chairman.
And I'd also ask.
Senator Serval.
Thank you, Mr. Chairman. And I'm sorry, they made me aware of this morning, and I forgot to deal with that. But I think basically what they're asking is that the language on line 545 and 549 have a 3-year enactment provision instead of a 1-year enactment. And I think I would make that motion as a line amendment.
Been moved by Senator Serval that it be extended to 3 years, not 1 year. And Senator Deeds seconds that motion. Any discussion? All in favor of the motion say aye. Aye. All opposed, no. Motion carries. Thank you very much. Appreciate the comment.
Thank you, sir.
Go ahead, Mr. Reinheimer.
The only other issue I'd like to address is also to include CALIA in the statute, whether the accreditation be through the Commonwealth, through FLEPC, or the international accrediting body, CALIA, to that also be included in there. And the potential or possibility of looking at size of agency as being a factor. Some of the smaller 1, 2, 3-man or woman police departments or sheriff's agencies in the Commonwealth might not have the resources or the ability to achieve that accredited status. Those are all the comments I have on that, and I really do appreciate the work y'all are doing, and I appreciate the time you give me today.
Well, thank you very much. Next person is Douglas Goodman of Ashland. Douglas Goodman of Ashland. Douglas Goodman of Ashland.
Mr. Chairman, I believe Chief Goodman had to leave. He emailed me saying he had to leave at 7 o'clock, so.
I'm here now. I apologize. Mr. Chairman, I'm here now, if you can hear me. Yes, sir. Thank you very much, if you can hear me. I want to thank you, Mr. Chairman, the members of the committee. I especially want to thank the patrons, Senator Locke, Senator Boysko, and Senator Serville for working with our membership, especially Chief Maggie DeBoard of Herndon. I know they've spent a lot of long hours in the last few weeks, especially this past weekend. Thank you for Chief Bradheimer for bringing up the CALIA accreditation as an option in addition to the state accreditation. CALIA can sometimes be referred to as the national body. I am a CALIA commissioner as well as being a 27-year veteran of Virginia law enforcement, and that would be very important to the 30 CALIA agencies that are currently active in the Commonwealth of Virginia as well. One of the other requests we would make, and possibly Senator Serville had this included in his enactment clause, is many agencies are struggling to ramp up their IT collection processes to comply with the existing language in HB 1250. And we would just simply ask that there be some time allowed for us to ramp up any additional fields that would need to be added to our records management system, specifically if it was to address investigatory stop or pedestrians or what have you that may require us to add additional fields. I know for my agency, we are compliant, but we're still waiting for our IT to be able to ramp up those additional fields. So we're actually having to do things a little bit long-handed to keep that data now. And the last item is just a concern over providing information to the Commonwealth attorneys. We should always work with our Commonwealth attorneys in the best interest of criminal justice, but we're just concerned about statements that officers may provide that are compelled as protected by Garrity and how that might be addressed in the language. Thank you very much, Mr. Chairman.
Thank you. Appreciate it.
Mr. Chairman.
Senator Serville.
Speaking to that very quick. Mr. Chairman, first of all, with regard to the Garrity language, we covered that, I think, on lines 926 through 930. It says that a law enforcement officer can redact any statements made by a law enforcement officer employed during an internal affairs investigation that may incriminate such law enforcement officer or otherwise be used to prosecute the officer. And that is specifically designed to protect officers who are given a Garrity warning. So I think we covered that, and that was something they highlighted and some prosecutors highlighted for us that we fixed. With regard to the other request that the chief had, and this is something I heard throughout this process, which is that the Community Policing Act that we adopted last year only allowed for about, I think, 70 days or something like that for law enforcement agencies to come into compliance, and that many agencies are having a really hard time doing that, and many are actually out of compliance, which is why I put a delayed enactment on our new provisions here. I didn't feel comfortable delaying the bill that we passed last year, though, because I haven't talked to Delegate Torian about it, but B, it's already the law, and it's a little tricky on how to do that. And but I've been hearing the same thing, though, that they're having a hard time complying with that law we passed last year.
Okay. The next person who signed up is Lester Fry of Richmond. Lester Fry of Richmond. Lester Fry of Richmond, you're on, if you're here.
If you could unmute your microphone.
Okay, I'm here now. Can you hear me?
Thank you, thank you.
Yes, sir. First of all, Mr. Chairman and committee, I do appreciate you allowing me to say a few words. I am real pleased in all of the efforts that have gone into this police reform Bill 5030, and I am in support. I am a local pastor here in Richmond, Virginia. I'm also the first vice president of the Baptist Ministers Conference of Richmond and vicinity. And we stand in agreement, and we thank you for doing all of the work that you have done, and we look forward to the changes and the safety of our people. And we thank you so much.
Thank you, appreciate it. Next person is Mark Bernard of Richmond. Mark Bernard, or Mark Barnard, as the case may be, from Richmond. Are you here?
Can you hear me, sir?
Yes, we can. Thank you.
Thank you, Mr. Chairman. Again, Mark Bernard from the Office of the Executive Secretary of the Court. Being very brief, the substitute that was admitted has resolved any issue that we had or that we were going to raise. So we thank the senators for that substitute. That is all. Thank you.
Thank you. These are the only ones I have that have signed up on this, but I understand there's a boatload of other people who would like to say something. If you'd like to stand up, speak up. So whoever you are, go ahead, speak up in order. How many do we think we have?
Mr. Chairman, Serval.
Yes, Senator Several.
I believe Mr. Anand, who was signed up, is now back in the room, if you want to call him back now that he's...
Mr. who?
Kofi Anand.
Okay. Mr. Kofi Anand, if you're here, from Herndon.
You might want to unmute, Mr. Chair.
Yes, good evening. Thank you for the opportunity to speak today. Again, my name is Kofi Anand. I'm the president of the Activated People and a steering committee member of the Virginia Coalition for Transforming Police. And I'm here to testify on the behalf of the coalition in favor of Senate Bill 5030. George Floyd's murder, as you know, triggered the largest running protest in our nation's history. And in response to this, the Activated People, we led a series of meetings across the state to listen to the citizens of Virginia to understand what their concerns were and what they thought is necessary to transform the policing in the Commonwealth. And the result of these meetings was something we call the Reimagining Police Package. Now, we feel that Senate Bill 5030 really is comprehensive, and it really goes really targets all of the issues that most of the issues that we are trying to address. And if passed, we really think that this would really set Virginia apart in order to achieve some of the equity in policing that we've all been marching and striving for. So, we understand that it's a lot, but we also believe that this is what's necessary in order to get the transformational change that we've all been seeking for. People have been marching through the streets for months, literally risking their lives, and they didn't do it in order to just get one kind of piecemeal type of bills put forth. So this is the type of legislation that we really think is necessary, and we really appreciate the Senate if they would go ahead and pass this bill. Thank you.
Thank you very much. I understand there are a couple more people that would like to say a word or two. You're welcome. Speak up and say who you are.
Hello?
Yes, go ahead.
Can you hear me?
What is your name?
I'm Emmanuel Harris.
Okay, where are you from?
I'm from Richmond, Virginia. I'm the president of the Baptist Ministers Conference. I'm a local pastor as well. I just wanted to say that I do feel that this bill is a positive step in the right direction. I will say it's a step, not the only step. I think the overall issue, speaking on behalf of, as an African-American male, myself and the community, is, the trust just needs to be enhanced. The accountability needs to be enhanced. And what we want stopped is the murder of innocent civilians, particularly African Americans, that are often on the other end of stops or whatever. So whatever can be done to enhance policing, to better train police officers, to allow accountability when unlawful arrests take place. The concern is who polices the police. In most organizations, you cannot regulate yourself. My experience is not only a pastor, but an auditor for the Federal Reserve. We regulate banks. So I think at the end of the day, we want to make sure that the police are regulated as well, and just for the sake of accountability. And that's all I have to say. Thank you.
Well, thank you very much for coming. We appreciate it very much. This is a landmark piece of legislation. We appreciate your comments. Is there another person? I believe there may be. Oh, Wayne Huggins. Oh, good. Wayne Huggins.
Can you hear me?
Yes, thank you, Wayne.
Thank you, Senator. On behalf of the State Police Association, I just, like my other law enforcement colleagues, want to thank Senator Surville and the others on the Senate Courts Committee for affording us the opportunity to have so much input. We could not have asked for more. The changes we have asked for have been made, and the changes you made today, I think, makes the bill even bit better. So thank you so very, very much. We very, very much appreciate being involved in this process.
Thank you so much, Wayne. Is anybody else? Okay. If not, it's been moved. Senator Deeds moves to report the bill, seconded by Senator Peterson.
My motion's to report and re-refer to finance.
Yeah, the motion is to report the bill as amended and re-refer to finance. Are you ready to vote? Let's call the roll. All in favor of voting for this bill as amended and re-referring to finance, vote aye. All opposed, vote no. Call the roll.
Senator Saslaw. Senator Norman. Senator Lucas.
Aye.
Senator Obenchain. Senator McDougal.
No.
Senator Stewart. Senator Stanley.
No.
Senator Chafin. Senator Deeds.
Yes.
Senator Peterson. Senator Serval. Senator McClellan. Senator Boysko.
Aye.
Senator Morrissey. Senator Edwards.
Aye.
9 ayes, 5 nays, 1 abstention.
Well, congratulations. Thank you. Again, this is a landmark piece of legislation. I want to thank the Senator Locke and Senator Sherville and all those that worked on this and all the people that spoke up as well. Now, we spent an hour and almost 50 minutes on this bill. It deserved every minute. But let's move on to, since the bill passed and it's been re-referred to finance, we'll move on to another bill. And Senator Lucas has a bill, Senate Bill 532. No, I'm sorry, Senate Bill, what's the number? Senator Lucas? 534, I believe it is.
5024.
5024. 5024. And this is a bill involving the Attorney General. So, Senator Lucas, would you like to say a word or two about your bill?
Thank you, Mr. Chairman, and thank you so much. The intent of this bill is to mirror the federal state law enforcement misconduct statute 42 U.S.C. at 14141 in the state code, as well as mirror the policing and justice reform bills currently going through Congress. The intent of the bill is to give Attorney General Herring the power to conduct patterns and practices investigation at the state level. In the last 4 years, the United States Department of Justice has significantly scaled back their pattern and practices investigations, and most recently, AG Barr has refused to conduct one of these investigations in Minneapolis. The current Justice in Poland policing bill before Congress will allow the state AGs to have the ability to conduct these investigations where the federal government declines to do so, and more than 18 state AGs, including Mark Herring, support this measure. We can't wait for Congress to pass that bill. We need to act now. As a matter of fact, Mr. Chairman, I have a personal story. In March of 2019, I sent a letter requesting an investigation into the policies and practices of the Portsmouth Police Department that directly discriminated against and deprived African Americans of employment opportunities because of their race, in violation of 701A of Title 7, 42 United States Code at 2000E-2, parentheses A. The information was received from Tanya Chapman, the first African-American chief of police in Portsmouth, Virginia. She was abruptly forced to resign without any explanation, as affirmed by statements from the Minority Police Officers Association. After making my request to the Trump administration's DOJ, I did not receive a correspondence acknowledging my request. Though my experience with the DOJ has its Civil Rights Division, is in my belief that they have zero interest in patterns and practices investigations. In times such as these, it is imperative that we have a state attorney general in Mark Herring with the power to step into the gap when the DOJ appears to turn a blind eye to malpractice, misconduct, and justice itself. Currently, the DOJ has to be called upon to come in and investigate in order for a pattern and practices investigation to take place. At the end of the preliminary inquiry stage, if the career attorneys and managers of the division's special litigation section determines that there is sufficient cause to investigate an alleged pattern or practice of violations of the Constitution, of federal laws, and that opening an investigation advances the federal government's interest in constitutional policing, the section recommends opening investigations to Assistant Attorney Generals for Civil Rights. If the Assistant Attorney General agrees that an investigation is warranted and authorizes an investigation, the division notifies the jurisdiction's Chief Executive Officer and Chief Legal Officer of the division's intent to open an investigation, generally in advance of any public announcement. That notice would generally identify the specific area of inquiry to define the scope of the investigation. Following that notification, the division makes existence of the opening of the investigation to the public. Mr. Chairman, even if the White House changes in January, the United States Department of Justice still has to use discretion of resources for when and where these investigations take place throughout the country, and given A.G. Herring's the ability to conduct this on his own means. We do not have to wait for the U.S. government to decide if they should prioritize Virginia. We can prioritize Virginia by showing we need an independent entity to investigate the police within our own state. In the more than 20 years since the divisions first undertook a pattern or practice investigation, the division has opened a total of 69 formal investigations. It has investigated or is currently investigating some of the nation's largest police departments. Puerto Rico with more than 18,000 sworn officers, and Chicago with 12,000. Some of the smallest departments, Ferguson, Missouri, with fewer than 60. East Haven, Connecticut, with approximately 50, and many in between. It has investigated big city departments like Seattle and Baltimore, small city departments like Warren, Ohio, and suburban departments like Suffolk County, New York, and Prince George's County, Maryland. The division has investigated departments in California, Arizona, Texas, Illinois, Michigan, Louisiana, Florida, Maryland, New York, Connecticut, and many places in between. And Mr. Chairman, with this explanation, I would really hope that this committee would advance this bill to have our Attorney General, or give him the power to conduct patterns and practices of investigation at the state level.
Thank you. Are there any questions of the patron? Okay, moving to the public. I understand there may be some people. Brittany Whitley, is she here? Brittany Whitley of the Attorney General's office. Is she here to comment on the bill?
Go ahead.
Brittany, are you here?
Go ahead.
Mr. Chair.
Yes.
Ms. Peterson.
Senator Peterson.
I think I have what I hopefully is a friendly amendment. It's a one-word amendment, but I'm looking at subpart B, which is the meat of the bill about what is unlawful. And maybe this is being gratuitous, but where it says conduct that deprives persons of rights, privileges, or immunities secured or protected by the laws of the U.S. or the Commonwealth, and I know that tracks Section 1983. My question would be, since it's conduct that deprives persons, would it be that unlawfully deprives persons? In other words, if you arrest somebody legally or you incarcerate them legally, then that may be depriving them of their right of freedom, but it's doing so in a legal way.
I would suggest that's language out of the federal code. It's probably pretty well interpreted.
And Mr. Chair.
Yeah, Senator Deeds.
Yeah, I would, up on line 17, it already says it's unlawful. So wouldn't it be verbose to say unlawful?
Yeah, no, I understand that. It just...
Okay, is Brittany here?
Brittany is from the AG's office.
Yeah, from the Attorney General's office. Brittany Whitley. While we wait on her, is Alan Charles Chipman of Richmond here?
Yes, I am. Hello, can you hear me?
Yes, please. Thank you.
Thank you. I just calling in support of this bill. I think it's important to have oversight from the Attorney General into pattern and practices, especially with some of the change in appetite at the federal level at the Department of Justice as well. And referring to the question around whether the conduct is legal or not, I have concerns around a certain pattern of practice, such as civil asset forfeiture, which Eric Holder under the DOJ actually rolled back the cash claimant of that for the federal matching program because along with Justice Clarence Thomas, Justice Sotomayor, people such as Rand Paul and other people as well were concerned around how due to the fourth and fifth constitutional violations, it would incentivize illegal stops that disproportionately affected Black and Brown members as well. And so seeing as though under our Virginia Code 19.2386, since some of these assets can be shared with other methods of law enforcement, I even was told by our Commonwealth attorney here in Richmond that they receive some type of portion of that to pay for office furniture and computers and things such as that. So if the oversight mechanism on a pattern of practice, which has been questionable as far as it might even be unconstitutional, but it is lawful, I would like for the Attorney General to have the power to look into that, to conduct the types of practices and studies into that as well, because really unless the police or the Commonwealth's attorney is really going to take that up, or we have a change at the federal level, there's not really much hope in oversight from someone that is removed from the profit motive of a practice such as that. That's just one example, but I'm just speaking in support of this bill, and I hope that we can have other forms of oversight into police and other patterns of practice.
Okay, thank you very much. Okay. Now, Brittany Whitley.
Hello, Mr. Chairman. Good evening. Can you all hear me?
Yes.
Yes.
Great, thank you. Greetings from the Barbara Johns Building. I'm Brittany Whitley on behalf of Attorney General Mark Herring and the Office of the Attorney General. We do support this bill, and we thank Senator Lucas for her leadership on this issue. As you can see, as drafted, we do intend to place this responsibility within our Division of Human Rights, who is charged with the prevention of and relief of unlawful discriminatory practices. They currently do engage in pattern or practice investigations when it relates to fair housing and educational institutions. And so this is a responsibility that will fit fairly nicely within their charge roles. Several other Attorney General's offices have been able to conduct pattern or practice investigations through their own state statutes. And we have worked with members of the Department of Justice to better understand what this role entails. Just to clarify a couple of things, this is a prospective look at a police department as a whole. It doesn't examine individual incidents of alleged misconduct, and it is intended to approach this investigation from the perspective of systematic unlawful violations of constitutional rights by law enforcement departments. And with that, I'll be happy to answer any questions, but again, we do support the bill and we thank you all for your leadership on this.
Okay, thank you very much. Any questions of Brittany? No questions? Okay, anybody have any further comments or questions about the bill? Is there a motion?
Move to report.
All right, it's been moved by Senator Deeds and seconded by Senator somebody.
Mr. Chairman.
Boysko.
Mr. Chairman.
That Senate Bill 524 be reported and re-referred to finance.
Yeah.
Is there a question?
Can I speak to that?
Yes, Senator Stewart.
Mr. Chairman, I guess I just want to say, while I love the patron and respect what she's trying to do, this gives me a great deal of pause because I see the ability for political mischief. And how do I say this? I would want to vote for this bill if Attorney General Ken Cuccinelli was in office, because it scares me to give AGs this much power in this category. So I hope everybody will think about that. It just seems to me to be a great political weapon for one side or the other that could really seriously be abused.
Of course, the federal government actually has this authority too, if they want to. Any other comments? So it's been moved and seconded that the bill be reported and re-referred to finance. Please call the roll. All in favor vote aye. All opposed vote no.
Senator Sadlaw. Senator Norman. Senator Lucas. Senator Obenchain. Senator McDougal. Senator Stewart. Senator Stanley. Senator Chafin. Senator Deeds. Senator Peterson. Senator Serval. Senator McClellan. Senator Boysko.
Aye.
Senator Morrissey. Senator Edwards.
Aye.
9 ayes, 6 nays.
Okay, thank you very much. Another significant piece of legislation. Thank you, Senator Lucas.
Thanks, sir.
We will now move on. We have three bills dealing with same subject matter, assaulting law enforcement officers. Senator Reeves asked to have his bill heard first. It's Senate Bill 5019, and this also would have to go to Finance if it's passed. Senator Reeves, are you here?
Thank you. Thank you,
Would like
Mr.
to explain
Chairman.
the bill?
Yes, Mr. Chairman, thank you. Senate Bill 5019 is a bill that would actually raise the penalty if an assault was to occur on a police officer. And just a little bit of background, especially during what would apply, it would enhance penalty if it applied under emergency situations, as we've been seeing here in Richmond and some others. Even our own Capitol Police have suffered some injuries as a result of some of the riots and things that were thrown at them. But law enforcement officers today deserve to be protected and backed by our legislators. According to the VSP, in 2019, 1,939 officers were assaulted in Virginia. Nearly 25% of them reported injuries. 25% of almost 2,000 officers. That's almost double the amount of people killed by police in our entire country in one given year. Given the violent protest and riots this year, this number is expected to rise. And during these intense and passionate times, we have witnessed peaceful protests turn violent because of extremist groups that decide to push their own agenda. Just this past Saturday in Portland, Oregon, rioters threw a 10-pound rock at police. One day later, 3 officers were hospitalized in Seattle after bottles, rocks, and fireworks were reportedly thrown at the officers. We've seen the same headlines here in our capital city in Richmond the past few months. Some of you are going to hear other bills today that are going to lessen the criminal penalty for assaulting a police officer. I personally think that's wrong. I think we've had law enforcement at the table. I know they've met with me and several of you on the other side of the aisle, and you've gotten to a compromise bill on some reforms. I'm asking that this committee do the right thing by the public servants that not only help our families stay safe, but they help us as we're here today as well. Mr. Chairman, that summarizes the bill. It's about a 2-line amendment to the bill that just increases it from a Class 6 felony to Class 5 with regard to violation during an emergency conditions such as the governor's call.
Does it require a mandatory term of 1 year in prison?
Yes, sir.
Any further questions? Okay. Is there a motion?
To vote against the police.
It's got to go to Finance if it passes. Is there a motion?
Mr. Chairman?
Yeah, who's that? Okay.
Joe. Question for the patron?
Yeah, Senator Morrissey?
Yes, thank you, Mr. Chairman. Question for the patron. First of all, is your bill almost identical to Senator Norman's SB 5010?
Mr. Chairman, I would say I don't think it's the same as Senator Norman's bill.
All right. Further question, Mr. Chairman.
Yeah, Senator Morrissey.
I noticed that your bill describes an assault or an assault and battery, and you would agree there is a difference between the two, correct?
Mr. Chairman, I'm not an attorney, but I know the code differentiates between assault and battery.
All right. Since an assault is simply a threat of bodily injury, which generally entails pulling back the arm with a fist as if you're going to hit the individual, is it true then that your bill would raise this crime of an assault on a police officer to a Class 5 felony, which carries 1 to 10 years in the penitentiary, but would not even require an actual physical touching of the police officer?
Unconstitutional practices.
Mr. Chairman, I would answer the senator. I'm not sure, and I don't know if that would be a requirement under the code statute. I would ask counsel that.
Mr. Chairman, the answer is yes. The crime includes not only an assault and battery, but also an assault, which is what Senator Morrissey has described. And so the effect of the bill would be to raise to a Class 5 felony, punishable for up to 10 years in the penitentiary for even an act that threatens a battery but does not, in fact, contact the officer.
For final question.
I yield.
Thank you. Your bill calls for raising the penalty yet again to a Class 3 felony if it occurs during a state of emergency as declared by the governor, such as some of the protest movements that we've seen. Do you realize that your bill would necessitate a sentence of between 5 to 20 years, which is the penalty range for a Class 3, if the defendant merely pulled back his arm as if he were going to hit the police officer but did not strike him? And did you mean to increase the penalty that much given that scenario?
Mr. Chairman, Senator Morrissey, that would not be the intent of what I would incur, but I think more precisely, which I think the senator is trying to get at, is an actual bodily injury to a police officer during that time frame.
I thank the senator.
Any other questions?
Mr. Chairman.
Mr. Chair.
Senator Serval.
Mr. Chairman, I had a question for council. So I just heard the patron say that what he was hoping to accomplish was I think a 5 to 30-year sentence during a state of emergency for a situation where there was a bodily injury to law enforcement. Can council confirm that this bill as drafted does not require any kind of injury whatsoever to law enforcement officer? It simply requires an unconsented touching done in an angry, rude, or vengeful manner.
Mr. Chairman, that's correct, but it does not even require a touching.
Right. Any other questions of the patron?
Mr. Chair. This is Peterson. I know we've got 3 bills in a row on this subject matter. Are we going to have the same witnesses testify and then take them up, or are we going to do these ad seriatim?
Well, this is the bill before us right now.
Mr. Chairman, I would point out that this bill is identical to Senator Norman's bill. So this bill, SB 5019, is identical to SB 5010.
Okay, identical bills.
Mr. Chairman.
Senator Serval.
Mr. Chairman, I'd move that we incorporate the 2 bills together.
Let's at least do that. Second.
Is there a motion to incorporate? Moved. It's been moved by Senator Serval to incorporate Senate Bill 5019 into Senate Bill 5010. There's been a second to that?
Second.
All in favor of the motion say aye. Aye. All opposed, no. Motion carries. They're incorporated. Is there a further motion on the bill? Bills. It's been moved by whom? I can't hear.
I'll make it.
Oh. Senator Stanley moves that the bill be reported and referred to finance, the bills.
Mr.
Is there a
Chair.
second to that?
Mr. Chair.
I can't hear. Who's second?
Peterson. Peterson.
Peterson seconded it.
No, I'm making a substitute motion.
Senator Stewart moves that the bill be reported and referred to finance. Senator Peterson.
I'd like to make a substitute motion.
Substitute motion. What's your substitute motion?
Can we lay it on the table? Just PBI.
How come my thing ain't working?
Are you making? I'm making a substitute motion, Mr. Chair. Motion to PBI.
Been moved and seconded that the bill be PBI, passed by indefinitely. All in favor of the motion to pass it?
Can I speak to the motion, Mr. Chair?
Yes, Senator Peterson, speak to the motion.
All right, and let me just say that I know we're going to have more discussion on this, and I appreciate what Senator Reeves has drawn attention to, and we've all been watching. and I appreciate the tensions and the people that have been in harm's way and all that they're enduring. But I do think that this is a code section that needs to be reformed. And in my opinion, by making the penalty more extreme and by making more mandatory sentences, we're going the wrong direction. We're going to get to a bill in just a few minutes, which is hopefully going to make this code section a little bit more flexible. And again, there's so many great police officers out there, but as I'll get to in a second, we've all had incidents, those of us who practice law, where this code section has been abused. And again, with all due respect to my friend Senator Reeves and Senator Norman, I think we need to put this bill by indefinitely so we can get to the next bill, which I think needs to address this code section. So I have moved to PPI.
Okay, would the all in favor vote aye, all opposed vote no.
Chairman,
Will the clerk call the roll? Yes.
No.
Senator Norman.
Mr. Chairman, all due respect, you told me 7 minutes ago I was going to be the next speaker. I think the problem with the bill is if you look at Code Section 18257 as it's currently written, right there on the first line, it makes a distinction between a simple assault or assault and battery. And what happens is when the bill was drafted with the enhanced punishment, particularly in a state of emergency, that it picked up just as the existing statute was written. And I think that the real issue is the assault that's been discussed, and I think that there is the opportunity to amend the bill to eliminate the assault as it pertains to the enhanced punishment and where there is actual an assault and battery that results in an injury. But I think the real focus of the debate is that there's a proposal, or has been a proposal, to reduce it to a misdemeanor, and that may be cured. It is absolutely incredible to me that during these times and what this city has experienced, that we would want to reduce the punishment. And you think back to when the mob was trying to storm the state capitol, and our Capitol Police stood on the front line there, had bricks thrown at them, had rocks thrown at them, had Roman candles shot at them, had one who was hit across the knees with an aluminum bat, and you want to talk about reducing the punishment? Absolutely incredulous. And so I think there's a way to fix this approach by making the distinction and eliminating assault, and I would object to passing it by indefinitely.
Mr. Chairman.
Senator who? Serval?
Yep, Mr. Chairman.
Yeah.
Do I have the floor? Thank you. First of all, I don't appreciate the comments from the senator from James City County, but I don't think or I personally don't think that type of amendment would solve the problem with this specific bill. It would help. It would definitely help, but it wouldn't solve the problem. And one of the things I've noticed in the public dialogue that's occurred about this concept is that there has been a real confusion about what constitutes an assault and battery versus what constitutes malicious wounding. And in the Commonwealth of Virginia, if you strike a person and you break their skin, it's already a felony. Whether you're a law enforcement officer or whether you're hit Scott Serval, it's malicious wounding if the skin is open and you're bleeding. If you broke a broken bone, if you get a concussion, if you have internal injuries, if you strike a person 4 or 5 times repeatedly, the Court of Appeals of Virginia has held that constitutes felony malicious wounding today. I would also submit that if somebody throws a brick at a police officer, that is attempted malicious wounding if they miss. If they hit and the officer is struck, if it wounds them in a certain way, that would become malicious wounding, depending if they get a concussion or if the skin's broken, or a bottle, et cetera. If it's a softer object, maybe it's more ambiguous. But I think there's a lot of confusion out there about what constitutes malicious wounding, and if folks, not talking about the people in this room, but the public was more aware of what the Court of Appeals has held constitutes malicious wounding, I think a lot of the confusion about this would subside. What we're talking about with regard to the bill coming up, and I think, which is what I think this bill reacts to, is that the Virginia State Police has found or the Virginia State Police reported in their annual report that in 70% of the situations where a law enforcement officer in Virginia is the subject of an assault on an annual basis, there is absolutely no injury at all to the law enforcement officer. And this statute, as it's currently drafted, creates a scenario that's entirely out of whack between the act that occurs and the punishment that is required under present law, which is what we're seeking to address. Nobody's trying to encourage anybody to assault anyone. We're trying to create a law enforcement, a statute that is more workable. I would support the motion to PBI the bill so we can get to the bill that I think is really one at issue today.
Okay, it's been moved and seconded to pass the bill by indefinite. Clerk, call the roll.
Senator Sasslaw. Senator Norman. Senator Lucas.
Aye.
Senator Obenshain. Senator McDougal. Senator Stewart. Senator Stanley. Senator Chafin. Senator Deeds. Senator Peterson.
Aye.
Senator Serval. Senator McClellan. Senator Boysko.
Aye.
Senator Morrissey.
Aye.
Senator Edwards.
Aye.
9 ayes, 6 nays.
Okay, thank you. Now we move on to Senate Bill 5032, Senator Serval's bill, which is assault and battery on a officer. This has gone through a number of iterations, and the number of people would like to speak on the bill. But first of all, Senator Serval, explain the version that we have before us today. This will be a substitute?
Thank you, Mr. Chairman. I would offer the substitute and move the substitute.
All right. Senator Deeds seconds the motion of Senator Serval to adopt the substitute. All in favor of the substitute say aye. Aye. All opposed, no. Motion carries. All right, Senator Serval, explain it.
Thank you, Mr. Chairman. The bill as a substitute is much shorter and I think cleaner. If you turn to page 2, you'll see that the bill keeps assault and battery on a law enforcement officer a felony. So it will be a felony for either an assault or an assault and battery if this passes. Secondly, between lines 38 and 42, it creates an option for a judge or a jury after a trial to make a finding or to reduce it to misdemeanor assault and battery upon finding that there's no bodily injury to the officer or the person, the defendant, has diminished physical or mental capacity or pervasive developmental disorder. And I'll talk about that in a second. I took that concept from our reckless driving statute, which basically says if a person has slight culpability, the judge can reduce the charge from reckless driving to improper. The last thing the bill does on lines 97 through 102 was an idea that was given to me by our Capitol Police Chief in discussion with this bill, which would say that before a felony charge for assault and battery against a law enforcement officer can issue,
What's the number?
there would have to be an investigation by a separate police officer and sign off by the Commonwealth Attorney.
I got it.
You can't get it online? So, Mr. Chairman, I think the substitute is they're having trouble getting that online.
I got it.
It's popped
Substitute's
up.
very
up there?
simple.
Okay. So that's what the bill as amended does, and I'm going to just talk a little bit about the policy here. Assault and battery against a law enforcement officer in Virginia, law enforcement officers are treated like everybody else until the 1997 session of the General Assembly when there was a hate crime bill pending. In order to get that hate crime bill done, law enforcement officers got added to it. But it was a misdemeanor until 1997. So this basically, we're not even trying to take the law back to 97 because we're not even offering to make it a misdemeanor in this statute. The situation as currently exists has an unduly prejudicial impact on minorities who tend to be involved in the system more nowadays, the mentally ill, and this charge often arises when very aggressive policing situations occur. One of the biggest problems with this statute right now is that it is the only statute on the books, the only one where the same person is the victim the lead investigator, the lead witness, and makes the charging decision. There's no other statute on our books where those four things are true, which creates a situation where a law enforcement officer has a conflict. Often they're very angry when these things issue, and they go down to the magistrate to get this warrant issued. This charge also, because of the existing mandatory minimum, is over-inclusive. You all have read the story, I assume, in the paper, or maybe read my column about how a woman who was arrested, an onion ring went flying, hit a police officer, got charged with felony assault and battery for an officer who got hit by an onion ring. I've had folks reach out to me about loved ones in their family who have a spitting reflex, and every time autistic children with spitting reflexes, and they're afraid every time somebody comes to their house that might happen, their child might get charged with a felony. I've heard testimony from other people about how they have developmentally disabled people in their family who, whenever you put a hand on them, they have a reaction. And so those type of people get picked up by this. It basically, creates a 6-month mandatory minimum for having an autistic reflex disorder. I've been given I have about 80 scenarios I've now been sent by people as this bill's been pending about different scenarios where this charge was issued. One involved somebody where water fell in an officer's shoe. Another one where a brownie
Mr. Chair.
Went flying.
Mr. Chair.
Senator Peterson.
Can I ask a semi-friendly question to my colleague?
Happy to yield.
All right. I guess my question would be, I understand that you're leaving the Class 6 felony on the books for what I'll call sort of your standard assault on a law enforcement officer. And then you have this subsection, which you're now adding to it, which means it could be a misdemeanor under certain circumstances. Can you actually explain to me, how would a jury be instructed? I mean, walk me through what a case would look like where you defend it on the merits, you lose, but then the jury comes back with what appears to be a lesser included offense. How would that work?
Mr. Chairman, what I would say to the senator is that you would have to draft a jury instruction that in the finding instruction where it says, if you find, this, and this, you have to find guilty of a felony. However, if you find that the culpability is slight and that the assault and battery occurred due to the person's diminished physical or mental capacity or pervasive developmental disorder, you may find the person guilty of a Class 1 misdemeanor. Or alternatively, if it's a case where there's no bodily injury, you get the bodily injury piece stuck in there also. So that's what the jury instruction would look like. It would happen in the guilt and innocence phase, not in the punishment phase.
Mr. Chairman. Mr. Chairman.
Senator Morrissey.
Mr. Chairman, I would also tell Senator Peterson that the jury instructions would not be unlike this situation where the jury was given alternatives: first-degree murder, second-degree murder, or manslaughter. Or another example, malicious wounding, unlawful wounding, and simple assault. And essentially, the jury will pick which offense fits the evidence that they heard.
Okay, Senator Morrissey. Senator Serval.
Thank you, Mr. Chairman. And so anyways, I don't know if anybody read the Virginian pilot story today. There was a woman who related a story in there who said she was trying to go to church late at night and meet with a minister, and she ended up getting tackled by a police officer, and as part of that got charged, locked up in jail for 2 months. For a relatively, what sounded like a minor touching incident to an arrest. There's examples of SROs where this has come into play. One example that was given to me was a child, an SRO wanted a child to stay in an office. The child wanted to go to class. As the child walked by the SRO, their shoulders came into contact. Law enforcement officer charged the child with this felony offense with a 6-month mandatory minimum. The most famous case is Commonwealth v. Adams. That was a 2000 Court of Appeals decision which held that a student who hit a law enforcement officer with a laser pointer in a cafeteria in a school had violated this statute. And as a result of that, the Court of Appeals affirmed that case. That child went to jail for 6 months. The next session, Delegate Vince Callahan introduced legislation to take striking a law enforcement officer with a laser pointer down to a Class 2 misdemeanor because of what this statute did. There's another case where somebody used their finger and said "pow" with their finger, and they got the Court of Appeals affirmed that felony conviction. So this is a statute that requires revision, and what we're not doing here, nobody is greenlighting assaulting police. Nobody is trying to attack our police with this bill. Nobody is encouraging people to throw bricks or other objects. This bill is simply getting rid of the mandatory minimum and creating a cooling off period before this charge issues and requiring an independent investigation and Commonwealth attorney sign off so that these charges, these elevated charges are brought when they're truly merited. The way the bill is drafted right now, if an assault occurs, the officer can swear out a warrant for misdemeanor assault, then they go and get somebody else to investigate it, get a Commonwealth attorney to sign off, and then they can get the felony. That's what it does. Mr. Chairman, the Virginia Sheriff's Association told me that I could represent that they now support the bill as drafted. I believe the chiefs of police and the State Police Association are now fine with the bill as drafted, and I would hope the committee would pass the bill.
Okay, any more questions of the patron? We do have some people who would like to say something. I hope they don't need to say anything anymore since the bill has been significantly
Mr. Chairman.
amended. Is
Mr.
anybody
Chairman,
out there, a bunch of
Steve
people
Benjamin.
have signed up to speak.
Benjamin.
Hobie,
Mr. Chairman.
they still there? Okay, yeah,
Mr. Chairman.
Steve Benjamin.
Yeah, a couple questions for the patron, please. Line 38 applies only to a person charged with committing an assault and battery. Is that the patron's intent that it not deal with those who are charged with committing an assault?
Mr. Chairman, I would say no, it's not my intent. My intent was to cover both assault and battery.
Just say all right.
So,
Second
Mr.
question.
Chairman, I think we could solve that, as the senator from Fairfax, City of Fairfax, pointed out by saying committing an offense under this subsection.
So moved, committing an offense.
That's correct.
Can I get a second?
So it's been moved and seconded to change to committing an offense rather than assault and battery. It's been moved and seconded. All in favor of that line amendment, say aye.
Aye.
All opposed, no. Motion carries. Okay,
The second point, Mr. Chairman, is that what this bill does is create an affirmative defense. That is, if someone can show that their degree of culpability is slight due to diminished physical or mental capacity or pervasive developmental disorder, or that there is no bodily injury. That's an affirmative defense. But then what is say that the affirmative defense applies only on the whim of a jury or a court. And so it creates a possibility of disparate treatment. Some people will benefit from this, others won't, subject to however the judge or jury feels. So the correction, the solution would be, instead of may find the accused not guilty, strike may and say shall find the accused not guilty. And I would also then strike on line 41, the clause that begins, but guilty of assault and battery, because as Senator Morrissey points out, it would be, normally you would expect a lesser included instruction of assault and battery to be given if that were the Commonwealth's wishes. So I think that additional language is unnecessary. And so my suggestion would be on line 40, change the word may to shall, so that there's not disparate treatment. So some people benefits, others don't. And then strike the language on line 41 that is unnecessary.
Is there a motion to that effect?
So moved.
Senator Boysko moves that the line amendments be as according to the way Steve Benjamin explained it.
Yeah, I'm not sure I agree with this.
And is there a second to the motion? Yeah. Is there a second to the motion?
Mr. Chairman?
Yes, Senator Searle.
Speaking to the motion, so I'm trying to play this out in my head, and just so we're clear how we got this language, I asked DLS to model this off the improper driving statute, and which incidentally the Court of Appeals has found does not apply in jury trials. It only applies in bench trials, which is kind of annoying. But in any event, I think that's why the language is drafted exactly like it is. It almost reads almost identically to the improper driving statute, but for the improper and A and B and all that's changed. So
we have a motion.
Yeah, I understand that, Mr. Chairman, and I'm trying to tease out exactly. It sounds to me like Mr. Benjamin's recommending that we sort of change this to an affirmative defense to just get a not guilty, as opposed to a vehicle for a jury to find a misdemeanor conviction. I think that's a distinct policy choice.
Yeah, Mr. Chair.
Senator Peterson.
Yeah, I'm not going to vote for this amendment, and here's why. What we do is we give a jury an option here, and I think Senator Morrissey explained exactly how it would lay out. A jury has an option to do a lesser included offense. You may have a situation where someone scuffles with a police officer. There's no bodily injury. That doesn't mean that they should get off completely not guilty. I mean, again, a jury has an option of doing a misdemeanor, and I think that's appropriate. So I understand what Mr. Benjamin's saying, that if you take that out, that could still be a lesser included offense. But I think by leaving it in the code, we leave it very clear to the fact finder that the jury does have the option here if there is, a lesser degree of culpability. So I'd prefer it stay as it is.
There's a motion without a second. The motion dies without a second. Is any further discussion? There are several people would like, if they would like to say something still, they're out there. Andy Elders of McLean, Teresa Champion of Springfield, and some others. Would anybody, it's getting late, I know, but would anybody feel obligated to say something about this bill? This as amended?
Yes, I would, please.
Okay, Hobie? Elders, is Mr. Elders here? Andy Elders of McLean? In favor
Yes, I
of the
am.
bill? What? Go ahead.
Can you see me?
We can't see you, but we can hear you.
That's fine then, thank you. Good evening, my name is Andy Elders. I'm the Policy Director for Justice Forward Virginia. I'm the Chief Deputy Public Defender for Fairfax County. I have handled cases like these for 15 years. This is a much needed reform to this assault on a law enforcement statute. I want everybody to know that these charges are often used in extremely minor cases where there's no harm to a police officer. In many cases, it's where police officers are using it to intimidate or punish people for being disrespectful to the police rather than actually harming or injuring the police. And it's often used in a retaliatory manner to prevent citizens from challenging police misconduct and police violence. Prosecutors in many of these cases defer to the police. And when they're making plea offers, they ask the police what they want to happen, which means that an important filter, which is supposed to be part of our criminal justice system, does not apply. And that means that, as Senator Serval described, the officer is often the victim, the charging party, the lead witness, and the chief negotiator, meaning that it's entirely within the police officer's discretion to decide whether someone is charged with a felony, whether someone faces a 6-month mandatory minimum. I will say I'm concerned even now that it will force someone, if they believe that they have a defense, to go to trial to avoid a felony. Even under the amendment, what we have now is a system where someone will no longer face a 6-month mandatory minimum, but a felony conviction can be a very serious impediment, and many people, as a result, will forego their opportunity to challenge police conduct, particularly abusive police conduct, because they fear a felony conviction and fear that when push comes to shove at trial, a swearing contest will go in the favor of a police officer rather than a layperson. It is often, as Senator Serval indicated, commonly used against vulnerable populations, and this law is disproportionately used against Black people who are systematically subjected to over-policing and who are disproportionately targets of police violence in Virginia. I encourage everyone to vote for this bill as amended, and I encourage that when push comes to shove, when this thing eventually, hopefully, ends up in conference, that we take a look at that amendment and decide whether we really think it's necessary. I thank the senator for his bill, and I thank you for your time, sir.
Thank you very much. Next person, Teresa Champion of Springfield. Teresa Champion of Springfield. Okay, Deidre Johnson of Richmond. Deidre Johnson of Richmond. Samir Khan of Falls Church. Samir Khan of Falls Church.
Hello, can you
Keith
hear me?
Johnson of Loudoun County. Okay, Keith Johnson. Go ahead. State your who? Oh, Mr. Khan of Falls Church. Okay, go ahead.
Thank you, sir, for your time. Good evening. I am a law enforcement officer in Northern Virginia and a former Marine, and I just wanted to thank Senator Surville for him allowing me to give some input on my experience in the last 10 years in regards to the way this bill is going to be brought in and passed. And the one thing that I wanted to add is there are people out there who do things such as, in my case, I had a person who fired a blank pistol at me, and this person had a weapon that had no projectiles, but I felt like I was being shot at. I could smell the gunpowder. I could see a silver handgun. And when it came time to charge this person after he was arrested, the only charge that fit was a felony assault because he did not batter me. No projectiles actually hit me, but that day still affects me. And I still think about that day where this person tried to get me to do a suicide by cop. And it's very important for you as the legislators to understand that there are varying situations and not everything is the same. And that was a case where we couldn't really figure out what to charge the person with. His intent was to get me to kill him, which I thankfully did not do. And he lived. And as far as I was concerned, when it came to when the prosecutor asked me what I wanted to happen, I didn't care if the person went to jail. I just wanted them to be a felon and not be able to get a real gun and hurt someone else. Or as this person apparently wanted to do, he wanted to join the army. So I just want to kind of bring that to the attention that I know a lot of people want to make these things not felonies or make them misdemeanors, but keep in mind that, we're out there and these things do, even if we're not physically harmed, it wears on us mentally, and there can be mental injuries. And that's the only thing that I don't see in this bill, which I have a concern with, because as we have gotten better in the Commonwealth with mental health and awareness, and the legislators gotten better about that, it's not fun having a gun pointed at you. And I know plenty of people who've had guns pointed at them or weapons, and they never were stabbed or shot. However, it still does affect you cumulatively. So I thank you for your time, and I just want you to consider that with this bill and any subsequent bills. Thank you.
Okay, thank you very much. David Hutchison of Virginia Beach. Wayne Huggins spoke earlier about the previous bill.
Mr. Chairman?
Yeah.
Thank you for the opportunity to speak. This is obviously a very important issue, a very emotional issue, particularly at this time in our history. And I just wanted to give you a couple of examples of what we're currently going through. I know there's been a lot of discussion about visible injuries, physical injuries, class 5 felony, class 6 felony. We had a trooper recently in Northern Virginia who had on a riot helmet and was carrying a riot shield, and he was hit so hard across the head with a club that it cracked his riot helmet. Fortunately, he was not injured. We've had any number of other examples in some of these recent protests and demonstrations where our troopers have been assaulted with rocks, bottles, pieces of asphalt, bags of human excrement, spit on, all manner of abuse, and yet they weren't physically injured because they had the proper protective gear on. Please keep that in mind as you consider this, that and I realize that this particular bill addresses that issue, but please also understand what these police officers, particularly our state troopers, are going through right now with some of these demonstrations and protests. Morale, I don't mind telling you, is at an all-time low, and messaging has to be part of the consideration. We have to tell these people that we appreciate what they're doing and we're going to stand behind them. So having said that, thank you again for the opportunity to speak.
Thank you, Wayne. Appreciate it. Shannon Taylor, Commonwealth Attorney of Henrico County. Is Shannon here? Yeah, the Honorable Shannon Taylor, Henrico County Commonwealth Attorney. Are you there?
Mr. Chairman, can you hear me?
Yes, thank you very much.
Sorry for all the technology. So yes, good evening, Mr. Chairman, and thank you, members of this committee, as well as Senator Surville for the proposal that he's put in today. And I'm speaking as the Commonwealth Attorney for Henrico County and a member of a group of the Virginia Progressive Prosecutors for Justice. And we are in support of what Senator Surville has put into place. The idea that we testified, I should say, my colleague and I, Amy Ashworth, before this committee. We were talking on various criminal justice reforms at that time to include what we had seen was the term overcharging of the use of this current felony statute. And at that time, I had offered information regarding what we had found in Henrico County, that from 2017 to April of 2020, we had 177 of the felony law enforcement officers, of which 164 had been reduced to misdemeanors in both general district court and in juvenile court. And also to refer to what Senator Surville had talked about, the infamous onion ring case. So we agree that this proposal does several things. Again, my group is against the mandatory minimum, so we see that we have struck that language in the current bill. We also recognize the concept of our individuals in our community who have the developmental disorders, who are suffering from mental capacity issues, and we do appreciate the recognition of that. We saw some of that in other bills where we were allowing courts to take in consideration those diagnoses and actually allowing cases to be dismissed in certain situations. So we appreciate that. We would also reference, Mr. Chairman, that we recognize that some of the language in subsection C is different with subsection B. We also want to let this committee know that our progressive prosecutors are working together to put together a proposal before this body to address hate crimes as an actual crime and not as a sentencing enhancement. So we look forward to working with the members of the General Assembly, and thank you very much for allowing me to testify this evening.
Thank you very much. Any questions? Okay, is there anybody else who would like to speak from the public? I don't have any more names. Is there a motion on the bill? Oh, three more. Okay, three more people. All right, three more people. I don't have the names, I don't think. Do I? Who else wants to speak? Teresa Champion of Springfield. Is she here?
Yes, sir. Good evening. My name is Teresa Champion. I'm with the Virginia Autism Project, and I'd like to speak this evening about the trauma that individuals with disabilities have experienced being charged with assault on a law enforcement officer. And I hope that the legislature will consider this and defelonize this particular charge. The disability community lives in fear of calling for help because they may have a loved one that does not have the ability to control any purposeful body movements. If my son, Senator Surville mentioned the spitting tic. My son has that. He spits constantly. My son has also scratched a police officer when they were trying to, when he was trying to be transported to the hospital. So these families are then forced to hire an attorney. They have a lack of social services for any help. They have a lack of medical care for their families. And now we're going to hold these individuals accountable for involuntary acts like spitting. If they have a felony charge and it puts their social services, if they have a felony conviction, it puts their social services at risk. Food stamps, social services, any of the safety nets these individuals barely have in Virginia. So I ask that you please understand, we are not greenlighting assault on police officers. You have charges that can be brought if there are very real and serious injuries. If there are mandatory minimums, individuals don't get bonds. And as we've already stated, the majority of these charges result in no injuries, 70%. So please remember families who experience the trauma of an encounter with law enforcement officer and are charged with a felony for something they cannot control. Thank you.
Thank you very much. Anybody else? Deidre Johnson, is she there? Keith Johnson? David Hutchison? Keith Johnson, is he here? Okay.
This is Keith Johnson, and I represent the Virginia Fire Chiefs Association as the first vice president. And really, I just want to thank the patron, Senator Serval, for his work and efforts on this bill. Certainly, this bill does protect our fire marshals as well as our career and volunteer fire and EMS personnel. So thank you, Senator Serval and staff, for your work on this bill.
You support the bill as currently drafted?
Correct.
Okay. Who else? Deidre Johnson, David Hutchison? Who? James?
Abrinio, Chairman. Can you hear me?
Okay, go ahead, James. I didn't get your last name.
It's Abrinio, Chairman.
Okay,
thank you, Chairman, and thank you, committee. I'm speaking really in two regards. The first is liaison for the National Alliance of Mental Illness of Northern Virginia. We want to thank the committee. We want to thank the patron for the efforts tonight. I think it's undisputed that the community of people suffering from mental illness are overrepresented in our jails. So anytime that we're making efforts to get rid of mandatory minimums, that's something that should be applauded, because it goes without saying that when you're in jail and you're serving an active sentence, you can't get the treatment you need. The jails do the best they can, but they're not the mental health facility that needs to be, that these individuals need in order to recover, to become better, and ultimately to heal and hopefully become contributing members of society. I will say on behalf of NAMI Northern Virginia, we applaud the efforts. We value our work with law enforcement as we're involved in crisis intervention training. And we do everything we can to help their efforts. And we're supportive of anything that de-escalates encounters between law enforcement and individuals. So we're happy about these efforts, and we think that the right issues are being addressed. I will say also as an attorney, this is no longer my role in NAMI Nova, but I've been practicing criminal law up in Northern Virginia for about 12 years now. And I think Senator Peterson mentioned it slightly. He said certain circumstances are where this statute has been abused. And I can tell you as a practicing lawyer, I've been involved in cases like that where I've been defending individuals with mental health issues that have found themselves in the criminal justice system, facing very life-altering charges that there was no visible injury or no injury at all. And they were forced to make hard choices. That's either between taking a misdemeanor plea offer and still serving a significant amount of time, or being compelled to either take a felony or go the not guilty by reason of insanity route. And those are just really difficult decisions to make. I'm sure that there's better attorneys in this committee than I that have been practicing longer and better skilled. But I can tell you these are the kinds of cases that keep me up at night. When it comes to this statute, I've lost a lot of sleep, as a lot of people I'm sure have. So I appreciate the effort made. And we will be around for any other information that you need from us. I've had the pleasure of living in Northern Virginia. I went to school in Charlottesville, and I grew up in the town of Grundy, Virginia. I've been a benefit of living across our great state. Mental health affects us all, and it's apolitical, it's aracial, and I'm just proud that the efforts are being made. But of course, we have a lot of efforts to keep going. So thank you for your work.
Thank you so very much. I believe that's everybody. Is there Any further discussion? One more? Okay, who's that?
Eugene Oliver is our last speaker. Eugene, if you could unmute your mic.
Yes, thank you. Thank you, Mr. Chairman. Thank you, members of the committee. My name is Eugene Oliver. I'm the president-elect of the Virginia Association of Criminal Defense Lawyers, and we are in favor of this bill. I'm a practicing attorney. I've been on the defense side for about a decade now. I was a prosecutor beforehand. This is a charge that throughout my career I've seen abused. I could recollect many of the ways that it has been, but the other attorneys that have testified have covered most of the grounds. One of the things that I also think is important is, as charged with a mandatory minimum, it does affect bond decisions. I've had a lot of clients held without bond due to the mere fact that it's a mandatory minimum 6 months. And when everything dust settles, it ends up resolving as a misdemeanor or sometimes even dismissed. So certainly, I would just echo a lot of the comments, but our organization supports this bill, and we ask for you to vote in favor of its passage. Thank you.
Thank you very much. Any further discussion? Is there a motion that we report the substitute?
Move to report.
Second.
Is there a motion made by whom? I can't hear it. Marcy?
Boysko.
And Boysko made the motion to report the substitute. Senator
Mr. Chairman, Servo.
Saslaw seconds the motion.
Mr. Chairman.
Senator Serval.
Sorry, I think I saw Mr. Quagliato trying to get your attention on screen. Maybe it just picked him up because he made a noise or something, but okay.
What?
Right.
Okay, it's been moved and seconded that the substitute be reported. Call the roll.
Senator Saslaw, Senator Norman, Senator Lucas, Senator Obenshain, Senator McDougal, Senator Stewart, Senator Stanley, Senator Chafin, Senator Deeds, Senator Peterson, Senator Serval, Senator McClellan, Senator Boysko.
Aye.
Senator Morrissey.
Aye.
Senator Edwards.
Aye.
9 ayes, 5 nays.
Motion carries. Well, thank you all very much. Sorry we went to 8:25, but we'll have no more bills tonight. The next meeting will be on Thursday at 9:30, same place. We look forward to seeing everybody, and thank everybody who came in to speak in favor or against, as the case may be, these various bills. So the meeting's adjourned.